Yes. My Lord's permission to make a mention that two matters, that is one is 1293 of 92 of 24,
Yes.
whereas absolutely there is no defect. After making proper verification, there is no defect.
What do you want?
Let this matter be listed by tomorrow. If there is any defect pointed out, I will withdraw
What is
the.
the urgency? You know, you see the board, 150 matters.
Or day after tomorrow. I am not compelling that matter to be
It's all right,
taken. No.
it's all right. What is the urgency?
My Lord, because I want a stay order. Because
Say what?
stay of
You are
DB
challenging what?
proceeding, ex parte order. The person is also staying at Dubai. In absence, there was an order, ex parte order.
Give your memo, we'll see. Just check
That-
how we can adjust.
My lord,
Yes.
pardon to mention, my lord, one proceeding which pending.
I would
before-
only request whoever wants listing, please give the memo. We'll just see how we can adjust.
Sir, sir.
Okay,
Sir,
please do that.
Well, criminal matter, my lords, the proceeding has been stayed by this Hon'Ble court, my lords. During pendency of the proceeding, the court has been issued summons to appear on 35, my lords. So the stay may be extended, my lords.
Stay is operating.
Operating and before the judgment of the 6 months extension, basing on that, the court has issued summons to appear on 35.
That judgment is already.
They are all gone. Present judgment.
You tell the court will
My
understand.
lord, so because he has directed for appearance on 35, that's why I am.
If you tell the court that.
I will tell my lords because
the court is directed,
if it will be extended, there will no problem. I will tell my lords. I will appear before the court below.
give the memo.
I have given. Just
Pardon to mention,
my lord,
my lord.
tomorrow or day after tomorrow, my lord.
See,
My-
My lord.
My lord,
the
I have filed,
problem, you try to appreciate the problem. this
My lord.
my lord, I have filed one IA to recall the vacation order, stay vacation order.
See, he is struggling for stay, you are trying to ask for.
To vacate the stay because the other side
Give the
is,
memo.
Pardon to mention, my lord. Mention that the waiving of the condition imposed by the loan trial court.
What is the condition?
The loan trial court directing the petitioner to release on bail. Imposing that the condition, he will appear on each date posting and under section 317 CRPC. Did not
You
take any
appear for one,
circumstance.
two dates. What is the problem? What is the urgency? Give the
petitioner is
memo.
student.
There is no urgency. If you,
Urgency.
what is the urgency? You can't,
No,
you are,
petitioner is the
you are
student, my
accused.
lord.
The condition is you go and appear before police station. Wait for some time. Keep on appearing for a month or so and alter that. Condition.
Petitioner is a student, my lord.
You are,
Petitioner is a student, my lord.
huh?
Petitioner is a student.
But there is now a vacation. Good.
But, tomorrow
He has a good
will,
pastime.
tomorrow will list him.
He has a good past.
Yeah, tomorrow will list him this.
I'm pardon to make mention, my lord. One CRLMC 879 of 2023, my lord. Compromise matter, my lord.
Yes.
My lord, in this case, I have mentioned 3 times, but this matter did not listed.
Battery settled. What is the offense?
307 and other offenses, my lord, and
Simple.
simple in nature.
Simple.
Yes, my lord.
Take it to see.
Obliged,
Are you
my
sure
lord.
that the injuries are simple?
Yes, my lord. As for my instruction. Obliged.
Instruction, now you see the paper. But when we'll see, then they will discover that it is a grievous injury.
With your lordship's permission, may I mention, my lord, item 125.
Yes.
I appeared for respondent number 5.
Yes.
The petitions are filed by the CBI. If your lordships could have, my lords, these petitions taken today at a time convenient.
Why do you perceive that it will not be taken up? I'll try.
I was told by
No.
my instructing counsels that I will
I
need to
think,
make a
see,
mention.
You know, everybody is in a vacation mode. Many of them will ask for adjournment. Let us see.
I'm here, my lord. I'm
Let us
here.
see. I'll try.
Yes, ma'am. I'm obliged.
Yes.
Page
We'll
1.
start. Any mentioning?
Yeah.
My lord.
Page
135.
Memo.
Item 1 to 9.
Mr. Mishra is giving some memo.
Appeal for hearing, my lord.
Okay.
Item
7, 9, my lord.
page wise document.
9.
Item 7.
My lord,
Yes.
item 9, I am appealing. I am in a death reference today.
I'll let them.
My matters may kindly be adjourned, my lord.
Okay.
Orders may come.
That's the best prayer one can make today. Looking into the number of cases.
Okay.
Wherever Mr. Padna is there, at them. Interim order will continue.
Wherever
I-
interim orders are there.
Yeah, that will continue, sir.
Item 7, my lord. Item 7. I play after vacation.
Yes.
Page 2,
Sir
item.
is waiting for some. Yeah, yeah, good, sir.
No, I am for item number 1.
Okay, one,
No, I am ready for arguing.
Yes.
Page 2, item 10 to 81.
Yes. Anything?
Page 3, item 19 to 34.
Any adjournment? No.
Page 4, item 35 to 46.
My lords, item 41, next week 15.
Oh,
You only seek adjournment, don't fix the dates. Let the court fix the dates. Okay.
Page 5, 47 to 59.
My lord, item 51.
Yeah.
Compromise matter, my lord, and second one on 14. Both party will appear on 15.
140?
Right.
Okay. Okay, yes.
Item 55,
Page 6, item 60
no,
to 74.
item 55, my lord. I mean VC.
Page 7,
Am I audible?
item 75 to 86. Page 8, item 87 to 96.
My lord, 93, my lord.
93? Yes,
Refer one adjournment.
adjourn.
Page 9, item 97 to 104. Page 10, item 105 to 112.
My lord, 103 permitted to withdraw, my lord. The withdrawal memo is already there. My lord.
Page 11, item 113 to 117. Page 12, item 118 to 125.
My lord, item 121, my lord. Let it for after batches. Intermatter is there, my lord.
Page 13, item 26 to 132.
127 can be taken up next week, my lord.
Page 14, item 133 to 143.
Item 135, my lord, kindly taken up after vacation.
Entry model is there. I am for the petition.
Are you opposing?
No, I am not opposing, but entry model is there.
Therefore, if you are opposing, I'll keep it.
Yes.
If not, I'll let entry model to continue wherever there is entry model. Yes.
134, my lord, is covered by my lord's judgment that income tax TDS matter, is covered, my lord.
So, right, what do you want?
I don't want to take it up today.
It will be taken up. If you want adjournment, it tell you.
Item 158.
Yes.
This is my lord.
And if-
Can be taken up today because my lord, counsel for opposite party and victim will.
why are you thinking that it will not be taken up in the morning at the first hour? Wait. Huh? I am very optimistic that I'll exhaust the board. If you will cooperate, I'll exhaust the board. Don't worry. Yes. Notice is not issued. What to do?
Notice so moto counsel for the opposite party number 2.
Somebody appear.
Yes.
Okay. Yes. One.
Sorry, my
May I just intervene, my lord?
Page 15, item 144 to 149.
What?
133, my lord.
Yes. What do you want?
My brother get the copy today, my lord. I want next week.
Adjourn.
My lord, pardon to mention, my lord.
Yes.
This is the matrimonial dispute. The matter has been compromised between the parties. Last occasion, the petitioner took time, but the matter is urgent to
What do you want? It is.
it may be listed on,
Have you settled the dispute?
my lord.
Have you settled the dispute?
Yes,
It's a matrimonial dispute.
Must.
But the parties are there.
Yes, my lord.
You bring them 14, 15, somebody.
15.
Bring them here.
My lord.
It is 498A.
My lord.
Yes. Bring them.
Obliged.
Yes.
I beg your pardon. May I just mention one item, my lord?
118. What is that?
My lord is ordered.
Okay. 100.
May I just
I 118, huh?
I may be permitted to mention, my lord.
Yes.
My lord, CRLMC 5101 listed under serial number 98, my lords. I seek adjournment for today, my lords. May be taken up after vacation.
19, 19.
98, my lords.
98. Adjourn. Okay.
Well, interim order may kindly be continued.
Okay.
Much obliged.
May I just mention item 55, my lord? I mean,
Yes.
VC. Both the parties will be coming that they have compromised the matter. Item 55. Can it be taken up at 2
12
p.m.?
o'clock. 12 o'clock. Settlement
12
all 12. Yes.
I'll come, my lord.
Yes.
118.
118.
118.
What is that matter? Why you haven't said that? What is that matter? 118.
My lord.
Indicated that it will be taken up first?
Yes.
Yes. What is this matter about?
First malad, private case, private party malad is and the subaltern malad strategy but copies are malad.
The pass over, let's see. Call it at least. Item 1.
Lordship, herein the petitioner who is a non-public servant is facing a prosecution for the offence under section 13(2) read with 13(1)(e) of the Prevention of Corruption Act, which is not permissible in law, and hence seeks for quashing of the proceeding. The facts leading to this application is that a case under section 13(1)(e) was registered against the husband of the present petitioner. And after conclusion of investigation, a charge sheet was submitted.
Yes.
The charge sheet is at Annexure 2,
Yes.
which starts from page 22. Lordship may kindly.
109 is there.
109, I will submit. 109 is not there. That is what I am showing.
File the charge sheet.
I am showing, Lordship. Lordship may kindly come to page 22.
Yes.
22, the charge sheet starts from page 22.
Right.
And the charge sheet, page 23, only contains the name of the present petitioner as an accused number 2. Lordship got it?
Yes.
And thereafter, in the brief facts of the case, which runs from page 24 onwards,
You are the wife of the principal.
the principal accused. The brief facts of the case, which starts from page 24 and till the end, there is not a single word against the present petitioner. Nothing is alleged against her.
What are the assets he has?
Almost. Lordship, I am, Lordship, 1 minute, please. Then what happens, Lordship, in the concluding portion of the charge sheet, which is at page 31, the investigating agency mentions that the husband is only liable for 13(2) read with 13(1)(e). Does not say that the wife is liable for the offence under section 109 IPC. And accordingly, cognizance is taken of the offence, 13(1)(e), and summons is issued to her.
109 cognizance.
No. Then charge is, the order of charge is at Annexure 3. Lordship may kindly see. It starts from page 32. Lordship may kindly come to page 33.
Yes.
Having regard, Lordship, second para I am reading. Having regard to the contention and counter contention raised at the behest of the parties, on consideration of materials on record, I find that there is sufficient ground to presume that the accused persons to have committed the offence under section.
See, neither cognizance under 109 is taken.
Yes,
or charge
yes.
is framed.
Then
Proceed
Lordship,
against a private party.
Lordship,
That's your case. And that's what you are.
Thing is that charge is framed.
109 is not there. Cognizance is also not taken.
Cognizance was not taken 109. Charge is framed against the petitioner. So almost all assets stands in the name of the petitioner. If petitioner,
But why there is
may I submit? If the petitioner, in view of these peculiar circumstances, we don't have any objection if the petitioner is acquitted or discharged. Thing is that all the assets stands in the name of the petitioner and
the husband will
that will
keep
go.
on explaining that is his problem.
That will go. That all the assets stands at this particular.
So why have you not invoked 109 then?
Court. That I got Lordship's point.
You have you challenged that charge?
No, the order has attended.
I have not that instruction. Thing is that asset will go.
Issue notice.
My lord.
No, the petitioner is the petitioner.
The thing is that your lordship.
Petitioner is admitted. It's not a public servant. Charge sheet was, although the charge sheet was filed, invoking the offences under section 13(2) and 13(1)(e) of PC Act against the principal accused, along with the petitioner. Read with 109 IPC against the principal accused and the present petitioner. However, the cognizance is taken.
No, in the Lordship, 1 minute, Lordship, there is a mistake. Lordship, charge sheet also does not mention about 109.
It is not mentioned.
Yes.
I've seen. However, the cognizance, the court below has taken cognizance for the offence under section 13(2) and 1E of PCX. PCX. The court below have also claimed the charges by order dated 1/10/2021 for offences under section 13(2) and 13(1)E of PCX. Mr. Moon, Learned Counsel for the petitioner submits that in the absence of the either taking cognizance of offence under section 109 or framing charges under section 109 of IPC, the private the trial against the present petitioner cannot continue being admittedly a non-public servant. Issue notice to the opposite party at the proceeding before further proceeding and in
Before the latter trial.
qua the present petitioner is stayed.
Lordship, when the date will be there.
Because thing is that
I'm saying qua the present petitioner. Principal accused.
Principal accused mori
Principal
jaychi
accused has died. The case has abated against
thing
him.
is that it the sole problem is
You address this is the issue to be.
so the PC Act offense stay bar statutory bar is there. Section 19 is a bar. So he may file an
Section 19
application
deals
keeping
with
in mind
sanction.
that can be urgent.
Why are you not challenging the charge then? Then this can't go on then.
No, charge to am favor achi.
Charge in the absence of 109, how will you?
No, am favor achi.
How can see?
No, set I got it lost.
It's a very difficult case. He has to be acquitted.
Then he has to be acquitted. I do not dispute on this side. I cannot say at this stage. But thing is that the asset will go. If that will be the proposition, then the asset will go because the principal accused is dead. That is the law. And যদি চোরি কেসরে মানে সে মরিগলা আবেট হইগলা মানে চোরি জিনিস পড়েব
300
চোরি কেস নহ এটা
চোরি কেস
unless one minute
just what I am answering
what do you suggest?
May I suggest subject to your lordship's kind consideration since your lordship is urging to the matter till the matter is decided let them file an application it will be urgent so because okay. The statutory bar is
Mr. Moon, submits that he would move an application before the court below taking an adjournment owing to the fact that the matter is already before court. Please the matter answer.
Lordship se कहले section 19
that needs to be examined.
Deals with sanction.
I know.
And if there is any irregularities in sanction,
matter where this court has to decide finally.
Lordship,
I'll not delegate it to the trial court.
Lordship, 1 minute and another half minute, Lordship. My learned friend was referring to the fact that the charge is in our favor. What he is hinting that when the charge was framed, section 109 was added. But there is no order of framing charge.
You have a difficult case. You get ready and address me. I'll decide it here itself. I'll not relegate it to trial court. I'll decide it here.
No, it will go. I know. But that asset is there. Asset will not go.
Asset.
You get ready. Whatever you want to say, you get ready.
Because she coach them IT return do.
Okay. Next item 2. Yes. Item 2. Yes.
CMC file for expeditious disposal of the 1cc case, my lord, arising out of NI Act, my lord. The case is filed since 2019, my lord, and now pending for the defense witness.
What says it is pending? Nothing is given. How you want expedite? What is it?
Stage, my lord, defense witness. As per instruction, my lord, though I have not annexed, my lord, but as per my lord,
it is there. Why do you worry? When counsel for the petitioner to withdraw the petition to move an application before the court below expeditious disposal of the trial pending before the court of SDJ Salipur. The present case is there is a court of a complaint under section 138 NI Act. Therefore, liberty is granted to the petitioner who is the complainant in the present case for participating in the expeditious disposal of the complaint case. The application is moved, change and the petition will be filed. Yes.
Item 3,
May I please? There also the petition also delayed in the proceeding in DV.
Yeah, sorry.
Proceeding in DV clause.
Yes.
Here the very initiation of the proceeding.
Who are you?
And the in-laws lordship.
Yes.
The person who has filed the DV case, in fact, he is not coming under the purview of the aggrieved person.
I'll just issue notices, matrimonial dispute, issue notice.
To say I have.
The petitioner, the counsel petitioner submits that he would move an application before the court below seeking adjournment in this matter before the trial court, owing to the fact that matter is placed before the court. Yes.
Okay.
Item 4,
Item 4, may I pray for after vacation?
Adjourn.
item 5,
Yes.
Item 5, my lord, I pray for an adjournment.
item 6,
Item 6, my lord, Mr. Mahapatra, London Senior Counsel is seriously ill. I have already entered appearance after obtaining no objection on 2nd of April.
And counsel for the petitioner seeks an adjournment on the ground that the earlier counsel, Mr. Mahapatra, is not well. Adjourned.
I have already entered appearance, my lord.
Yes, no problem.
Let it be come in my name.
Huh?
Let it come next
Name
week.
should be reflected.
Next week, lordship, any date, because last order, lordship directed to take instruction.
कौन instruction आपण आर सबले देखंतु लॉर्डशिप काइले से सबले टाइम दिछन
Today there is no time.
पण जानना
Yes.
item 8,
Next week, any date, lordship.
item 8,
Yes.
password.
No password.
All
adjourned.
passwords, both cases.
आज ही password दिए होंगे.
Urgent.
See, he's taking adjournment after adjournment. What is this?
So what means? Appeal twice filed that has been disposed of, thereafter passing of affair.
See, on 9/1/2024,
372N.
14,
372N.
huh?
372N and 373. FR passing. For disposal.
Investigation is still on.
My lord. I'm instruction, but in fact, that is 2022 case.
See, the matter was agreed listed on 9/1/2024, 2/2/2024, and 13/3/2024. The matter. The problem here is leave the matter. Whether on that those days anybody appeared or not, I don't know. Whether anybody appeared, that's the very faulty way of preparing the. If so and so PK Rautraj, whether he is present or not, who knows?
If they not appear, my lord.
If they are not appearing, their name should not be there, na? Okay, what are these people doing here? How will I know that in the last whether somebody appeared or not? You don't write none appear for this thing. You write appearance. If somebody is not appearing, you don't write his appearance.
Urgent matter and none say none
Adjourned to August. None appeared on behalf of the petitioner. Adjourned to. And hence, if nobody appears, don't write the name of the counsel. Yes.
item 10,
One of the petitioner has filed this case for questioning of the entire proceeding on the ground of the marriage between the petitioner and the last petition.
Compromise.
376. Foxo.
Now they are major and they are blamed.
Mahapatra sometimes someone.
same order, non-appears.
August. None appears August.
13,
My lord, passing of criminal proceeding on the ground of compromise. Party is here, my lord.
But you are there.
Father and son. Accused is the son and informant is the father. Open number
323.
323 506.
Who are they?
My lord, petitioner is the son and OP number 2 is the father.
Father and son.
Father has given a pair.
And this boy has beaten him. What is he doing? Ask him.
କାର ନବା ପାଇଁ ପାଟିତୁଣ୍ଡ ହେଲା ଆଉ।
What is he doing?
କଣ କରୁଛ? କଣ କରୁଛ? ପାଠ ପଢୁଛି।
BBA complete କରିଛି ଆଉ।
I can't impose cost also because you impose cost again the father.
ମାନେ ସେ ପୁସ୍ତକରେ ପଢି ମଦ ଫଦ ପିଉଥିଲା। ଛାଡ଼, ଏବେ ଭଲ ବାଟକୁ ଆସି
ଭଲ ବାଟିଲା ଆପଣ କହୁଛନ୍ତି ନା ସେ 17 ଆସିଛି।
ଆପଣ କିଛି ନ କରିବା ଭଲ।
He should be penalized something. You have to do something.
ଯଦି ସର୍ଭିସ କରିଥାନ୍ତା ତାହେଲେ କଷ୍ଟ ଫଷ୍ଟ କରିଥାନ୍ତେ।
Forget about the monetary cost.
Petitioner appear in this court.
Yes. What are the offences?
Offense, my lord.
363, 360.
My lord. Informant.
ଆସିନାହାନ୍ତି ପରା।
ହଁ ଆସୁଛନ୍ତି।
ସଞ୍ଜୟ କୁମାର ପଣ୍ଡିତ ଆସିଥିଲେ।
Where are they?
363, 366, 294, 34.
Where are they?
My lord.
Ranjan Jena.
ସଞ୍ଜୟ କୁମାର ପଣ୍ଡିତ
Sanjay Pandit.
ସେ ଆସିନାହାନ୍ତି ଯେହେତୁ victim ଆସୁଛନ୍ତି।
He is the informant.
My lord, victim age is 19 years.
ହେଲେ ବି ତ
Where is the informant?
My lord, informant ଆସିନାହାନ୍ତି।
How can the FIR be quashed without the?
My lord, victim filed an affidavit.
Maybe informant has to be there. All like this. See, there is a danger. Then he will come and challenge it.
Challenge it.
Because these are, family dispute. Very dangerous. Must be the father must not be supporting the girl.
My lord, I am the already we continuing our conjugal life.
In the just earlier, I have done the same thing.
Yes.
Bring the father. If you want, I will issue notice.
We'll file affidavit.
Huh?
We'll file affidavit next date.
With the father he'll come.
ବାପା ଆସିବେ।
ବାପାଙ୍କୁ ଆସିବା ପାଇଁ କହୁଛନ୍ତି।
Who is Sanjay Pandit has to come.
ବାପାଙ୍କୁ ଆସିବା
He
ପାଇଁ
is the informant in this.
informant.
Father of the victim.
Father of the victim.
Next week.
ଦେଖ ଚିନ୍ତା କର।
You bring Sanjay Pandit. Otherwise, if you quash it, it has no meaning, He will come and say, that is my affidavit. Next week, Sanjay Pandit. Okay?
22.
Hey, so go ଆଣିବେ ନା notice କରିବେ?
Mediate ଆଉ victim ନ ଆସି କେବଳ ବାପା ଆସିଥିଲେ।
Don't do that, sir. These are ଗୋଟେ ଥର ଆସିବା ପରେ କଷ୍ଟ ଲାଗୁଛି ପୁଣି ପରେ ପ୍ରୋବ୍ଲେମ ହବ।
ଟ୍ରାଏଲ କୋର୍ଟ ବାରମ୍ବାର ଯିବ।
ଫାଦର ଝିଅକୁ ସପୋର୍ଟ କରୁନଥିବ ସେ କୋର୍ଟକୁ ଆସିଲେ କମ ସେ କମ ସମସ୍ତ ସାମ୍ନାରେ ତ କହିବ ଜୀବନରେ କିଛି ପ୍ରୋବ୍ଲେମ ଆସିବ।
ଫାଦର ଆସିବ କିନ୍ତୁ victim
କାହିଁକି ଆସିବ?
ଆସିବେ ନା?
They don't understand the implication.
ମର୍ସି ନା କଣ?
Yes. 20?
22.
ନାଇଁ notice କଣ?
Notice ନାଇଁ notice 22.
No, 22. Here also the same thing.
Recall person 311%.
None appears for petitioner adjourned.
Yes. 23.
May it please your lordship.
Here the petitioners have filed this petition for quashing of the proceeding matter. The mother of the petitioner number 2 lodged a written report alleging that while they are not at home, a boy has taken away her daughter and some ornaments and cash was taken away. Now the case is pending, but the mother filed a habeas corpus petition.
Fair.
48.
Yes, my lord.
Yes.
The annexure 5, my lord.
Annexure 5. Okay.
My lord, on the basis of the complaint filed by the opposite party number 2, my lord, the London magistrate directed to 156(3) to lodge the FIR, treated as FIR. It is a counterblast. This FIR.
Yes.
And this FIR lost 498 307.
Yes.
And after filing the charge sheet, my lord, that for the investigation complete, then the 307 deleted the. And now the London magistrate take cognizance against me, my lord, under section, your lordship can turn 111, my lord.
Yes.
Sorry, my lord, 112. 7/4/2020, my lord. Where the in-laws, my lord, that the petitioners are the father-in-law, mother-in-law, and the brother-in-law, my lord.
It's all right, but why should it be fast?
My lord,
And are you agreed that 307 should also be included?
No, my lord, that is the cross, that is the counterblast. My submission before your lordship, my lord. It is the case, against the petitioner is the general and omnibus allegations, my lord. After the sort of
all matrimonial dispute are like that.
no, yes, my lord, legal obliged now. That
This being a matrimonial dispute, I'll simply issue notice.
yes,
Let us see.
issue notice, your lordship.
Matrimonial dispute, let us see.
Notice.
Issue notice.
Your lordship.
That there is a case.
That old persons, my lord, old man.
No, they are on bail.
Oh, yes, my lord.
So then what could?
That proceeding, not that every day that summons has been issued by the magistrate, your lordship.
You move
What the
application under 205?
205 already dispensed, your lordship.
যদি compromise হবে।
Short
কোনো একটা matrimonial dispute যদি ହେଇଗଲା ଭଲ ତ।
short period, your lordship, in the reopening that
What
your
do you
lordship.
want?
Because the stay of the proceeding, lord.
Don't say, I'll just see. Response of the petitioner submits that he would move application before the court below, seeking adjournment in this matter, owing to the fact that the matter is submitted to the court, and there is a scope of settlement in this matter being a matrimonial.
And notice also, my lord.
Notice your
Opposite part. Notice to opposite.
Yes, yes, ma'am.
So I don't know 20 lordship.
20 is already gone, sir.
Arjan ହେଇଛି।
Adjourn ହେଇଛି। ଆପଣ ଆସିଲେନି ଆଉ କଣ କରିବେ? Next week. Settlement ହେଇଛି ତ?
Settlement.
Next week पे ରଖବା। ପାର୍ଟି ପଳେଇ ଆସିଛନ୍ତି କି?
Party
ଆଜି ଆଣିନାହାନ୍ତି ତ? ହଁ ତାପରେ next week ଆଣ। ଆଜି ଆଣିଥିଲେ କୁହନ୍ତୁ। Yes, next.
25. My lord, item 25 kindly take it up next week, my lord.
ଆସିବେ।
Compromise ଆସିପାରିଲେନି communication
ଆସି
gap.
ପାରନ୍ତି।
Communication gap ରହିଲା ଆସିବେ।
ଆସି ପାରନ୍ତି କହିଲେ invitation
ନା
print
sorry
କରିବେ, ଡାକିବେ,
sorry sir
court
ଭୁଲରେ
time
କହିଦେଲି।
ଛୁଟି ପରେ ଆସୁ। ଆସି ପାରନ୍ତିରେ ଆମେ
Communication
If
gap
you are
ରହିଲା।
sure that they are coming, then I'll.
My lord, communication
के बाद आती और जोगी
communication gap ରହିଲା
You
contact
also enjoy vacation after vacation.
next week ଆସିତ next week.
ଆଉ ଥରେ ଆସି କହିବେ adjournment ମାଗିବେ।
ନା next week
settlement matter ରଖ 20 ତାରିଖ ଦିନ 20
ଆଜ୍ଞା
ହେଇପାରିବନି ବହୁତ problem
ଆଜ୍ଞା
ଆଉ ଡେଟ୍ ଲାଗିଲା ପରେ we are calculating and you are simply coming and asking.
my lord
It's easy for you to do it but it's very difficult for us.
20 ତାରିଖ ଆସିତ।
26. It's
Asur.
so easy for you to tell 150 matters. How will you do?
Please, my lord.
We are not on the mercy of your clients. You don't understand that.
next week ଆସିବେ ଆଜ୍ଞା।
ଆସିଲେ ଦେଖିବ ଆସିଲେ
26.
ଆଜ୍ଞା
26 I'm there, my lord.
I have to take instruction. I have to take
26 I'm there, my
instruction.
lord.
Today is very
Let it come along with earlier case.
earlier which one?
My lord, 26
Earlier dispose of
982.
26. 964.
982 is there already.
982 of 20.
Take it up to lunch, my lord. Mr. Roy.
Maharana.
That
Lord, I'm there, my lord.
death hai Can I have the judgment? It can be. Division bench and Supreme Court also.
Do you want you
Asu. How do you
Mr.
My lord, 26 I'm there, my lord. I'm appearing through virtual mode.
Maharana.
My lord, 26 I'm appearing through virtual mode.
My lord, already
appearing.
My
Perhaps
lord,
appearing.
I'm there for the petitioner, my lord.
Yes.
My learned friend wants time.
Yes.
But this is a case, my lord, where the petitioner is the main principal accused. Husband has died. But still the vigilance people who want to prosecute the wife who has been arraigned as an accused in aid of 109 IPC, my lord.
Yes.
So therefore, my lord, the three ingredients which is required, one has to conspire, instigate or aid. How I am responsible, my lord, already I am stand covered by your lordship's decision in the case of Swarna Lata, my lord.
So it needs little hearing.
Yes, my lord.
Fix it up, huh?
Yes, my lord.
Mr. Rajit Roy.
My lord, I only place a stay of further proceedings, my lord.
Stay no adjournment application.
Mr. Rajit Roy submits that he would move application for the court below, seeking adjournment, owing to the fact that the matter is subject to court. Okay.
27. No, no offense. First time listed. First time listed this case.
First time listed. What is this matter?
No. Question.
Huh?
Recall the Schedule 1 to 7. 311%.
After vacation.
28.
None appears.
28.
Display is working or not?
Yes, sir.
28. Show me the display. 28. Okay. What is this matter, Mr. Pragada?
What are the passing of the was the in-hand power under section and was the appropriate order किसी prayer लिखना prayer लिखना 26/2/2004 by Lord by this passed by special court passing proceeding passing election the date
Immediately after vacation.
29. 29.
Please, the Lordship. Pardon to mention, Lordship. Lordship, item number 28, Lordship.
28 was the earlier matter.
Yeah, approved.
Yes, yes.
Lordship, the petitioner has challenged for default bail, Lordship. Lordship, may kindly have a glance at Annexure 1, Lordship. Annexure 1, page 15, Lordship.
Yes.
His prayer for default bail was rejected. Lordship, the due date of 180 days was to be completed on 23rd of February. But the charge sheet was filed on the 181st day, Lordship, for which his prayer for default bail was rejected, Lordship. Lordship, may kindly have a glance at the rejection order. Page 15, Lordship. This petition is filed under section 167(2) of the CRPC. Accused Gopal Pal was taken to custody on 28/8/2000.
But you filed the application on 26th.
Yes, Lordship. 2 days after.
Yes.
His right was never.
Yes.
His indivisible right has already been
Yes,
violated.
23/2/2024. 180 days over. Okay. And he files an application under 167(2) on 26/2/2024.
Another time given matter.
Next week.
Next week.
He'll seek instruction. No issue notice. Next week.
Yes, sir.
Just check it up. He's entitled for.
Yes, yes.
Yes.
Item 29.
May it please, Lordship. Lordship, this case also arises out of a default.
Same. Another case, my lord. Identical case, my lord.
Same,
Instruction.
Both the matters reach together. Next week. Next week. He'll seek instruction.
My lord.
30.
Yes.
Petitioner has filed this case challenging the order of cognizance as well as quashing of the entire criminal proceeding. The petitioner was not named in the affair and no allegation has been made in the affair.
Yes.
In the charge sheet, he has been added as an accused.
Yes.
He is the miller. The fact is that the gunny bags should have been supplied by the department for packaging of the PDS rice, but that has not been supplied. So that has been purchased and the payment towards the gunny bags has been made to the millers. As per the guideline, the same should have been supplied by the corporation, but the same has not been done and the amount has been given to me. An audit objection has been made and thereafter the FIR has been filed against the concerned accountant and civil supplies officers. At the time of charge sheet, I have been added and accused, stating that since the benefit has been given to me, the money towards the gunny bags has been given to me. For that reason, I have been added and accused. Now, there is the guideline. Your lords may see the FIR.
Yes.
Page 14 is the FIR. 15 and 16 the relevant portion. Enquiry last page 15 last. Yes. Enquiry further revealed that Messrs. MP Rice Mill Limited Baripada has been paid 4,29,287 towards cost of gunny bag
depreciation for KMS 2006-7 by case voucher number and so many my rice mill is also there. And for the said reason, the charge sheet has been filed against us. Your Lordship may see the guideline, page 19, the annexure 2, the relevant portion, page 23, my lord.
Yes.
Clause 9, IX.
Yes.
The district manager OSS Limited shall be responsible to ensure that the farmers are paid the cost of their paddy at the MSP fixed by government, and dues of the farmers are paid on priority basis as per the food and procurement policy government. All payments of farmers to be made through account by checks, my lord. The district, my lord, thereafter next.
You also got the check.
No, I have got the check, and I have the gunny bag has been supplied by us, and that has been the amount has been paid to us.
Yes.
My lord, the similar.
I understood this.
My lord, these similar matters are posted to 20th. The CSO and accountant has also filed.
CSO can't get it.
Yes, CSO.
No, that is the maybe, but they have filed the for interpretation.
Right, but you have a case. You have
I have a case.
Yes.
Next page.
Case of the prosecution is that the public servant in connivance with the present petitioners, millers, without supplying the new gunny bags.
He has supplied the gunny bag. You
No,
have paid
he
the
has
check.
not. He has not supplied the gunny bags.
But you paid the check.
He filed the bill and payment was made without proper verification.
Show me where you supplied.
My lord,
That is the conspiracy. You
Yes, my lord.
and all you got.
No,
the check.
They all
got
connive
requested
with
test
each other.
without supply.
my lord,
connive with
only
each other and
writing of
disbursement.
connivance.
Show me anything in the record
I am showing the records, my lord.
where
As
you
per
have
the-
supplied.
I have supplied that is your lordship may see. That is the guideline, page
The
43.
guideline is not supplied.
No, I am going one by one, my lord.
Anyway, these are matters are coming up on 20th.
My lord.
Least on 20th.
On that case also, so they have filed, because I am the advocate for the accountant also. He has filed the statements, and the same has been allowed by the corporation
Anyway,
in that case. Because
20th we'll examine.
my lord.
All other matters. Give the number.
Well, that is there in the list, in the list that is there.
Ajib,
Aji sabu janga asche.
20th, why are you saying 20th?
No, other files I have not brought. That is that has
Those
not
matters
been.
are listed on 20th.
Yes.
That's what I'm saying. 20th will for the order. Okay? 20th will discuss. But you show me whether you have.
Yes, in that case I have annexed those documents. Because
in this case, you have to show me that you have supplied the
I will show from those cases, because the annexure is given by the accountant.
Your long and short of your matter is gunny bags were supplied by
Yes,
you
yes.
and you got the check.
Yes.
You are out.
Yes.
Their case is you have not supplied the gunny bag.
No,
but
they are-
you taken the check.
No, that is not their case. Their case is in connivance with that. They have paid the excess bill to me. Excess bill.
But
Depreciation cost. They are saying about depreciation cost. I am saying about the cost of the gunny bags, because it is the guideline. They have to pay the cost of the gunny bags, or they have to supply the gunny bags.
there is no dispute regarding.
No, my lord. There is no dispute.
That is the dispute.
No.
That is the dispute. That is the prosecution.
He may say
Without
it
supplying
is on
the
record.
prosecution.
Show me on that day.
Yes, ma'am.
Yes.
May I pray the date has been fixed to next week. May I file a time petition there, my lord?
20th.
For charges.
On your case,
20th,
your
sir,
lords.
tomorrow is holiday. All holiday.
No,
And
last.
ଆର
All
ସପ୍ତାହ
holiday. After
ଆର ସପ୍ତାହ ଅଛି ନା ସେଟା 20th ତା
ଆର
ପର
ସପ୍ତାହ କଣ 20th Monday?
ନାଇଁ ତା ପର ମଣ୍ଡେ
ତାର Monday. ଓ ଠିକ ଅଛି.
Last occasion, in respect to others, your lord were not inclined. That's why.
No, I have not prayed for. No,
Anyway,
you are not the advocate there.
Anyway, 20th.
I have not prayed for any adjournment petition there also.
All right, no problem. Okay. Next.
ଆପଣ advocate ନାହାନ୍ତି ଅନ୍ୟ କେସରେ
21.
ଆପଣ certificate he has not given.
Oh, that is.
Why should I have given the certificate? I am not least concerned. Though I am the advocate, I am not the least concerned about that case. The petitioner is least concerned about this.
Yes.
May it please your lords, my lord. I have challenged the order taking cognizance passed by the special judge in taking cognizance of the offense, not on facts, on points of law, my lord.
Yes.
My lord, here the petitioner now is under prosecution for the offense under section 7 of the PC Act, my lord. My lord, fact that on the same set of facts, a departmental proceeding was also initiated against the petition.
Right.
In the departmental Annexure 2 series, my lord, may kindly see the charge
You are exonerated.
I have been exonerated. I have also taken specific grounds in that respect. My lord may kindly see. My lord, paragraph 13. onward.
Radhesham Agarwal.
Paragraph 12, my lord, Radhesham Agarwal, which has been taken note of by this honorable court in Vinakatan Pani's case, which I have argued, and it was seriously opposed by the government advocate. Honorable Chief Justice was pleased to allow the application.
That's a departmental proceeding or adjudicating?
Departmental proceeding.
Not adjudicating.
No, departmental proceeding. And my lord, everything has been taken note of. I think that judgment must have been thrown in my other counsels. Well, let me see. All the points. I have also got the copy.
But I have written a judgment distinguishing this.
So far as your lordship, that departmental proceeding is concerned. So far as
My lord, here, my lord, what has actually happened? Even my lord, the vigilance inspector, who is the investigating officer in this case, he has also been examined during inquiry. And after considering the entire thing in detail, in extenso, so to say, my lord, the authorities, my lord, may kindly see at page.
This Minakatan is arising out of departmental proceeding.
Yes, my lord. I was the counsel arguing the case, my lord, and prolonged hearing was going continued, and ultimately, after considering all the judgments.
Then I will issue notice prolonged hearing again.
My lord, may see. What I want to say, prima facie, I want to draw my lord's attention to the findings arrived at by the department, considering the statements in toto, page 59, my lord, may see.
Yes.
Findings. There, my lord, will see the statement of PW3, who is Srimati Anusaya Senapati, Inspector Vigilance, Jaspur Unit.
Yes.
My lord, may see the statement. That is the basis of the case. What do
you say, Mr. Mohammed?
So far as
what they are doing, my lord, I am saying, with all respect, because I have got all respect for though he is junior.
The respect and affection.
No, and affection, we respect me. Like here, they are taking time. What they are doing, my lord, in one of my case, my honored friend has taken time thrice in this court. They have approached by authorities to renew, to reissue or to notice for further inquiry. After completion of the inquiry, and day for yesterday, I got the order stay that the vigilance people have prayed for further inquiry, and we have got no other way out but to go for inquiry, further inquiry. Here they are taking time. It's another case, my lord, where my non-enforcement has taken time. I don't know.
Now cognizance, everything is taken.
Yes.
They will move application.
No, but they are by departmental proceeding. I have been exonerated.
Again departmental.
Again departmental proceeding. Yes, sir.
The thing is that
my lord, what is happening, my lord,
and criminal proceeding concerned, it's just like, with all respect, it's just like it's creating a situation like that.
All right. Minakatan
After Minakatan Pani's judgment, Supreme Court judgment is there, and this honorable court's judgment is there. It cannot be automatically dropped.
Not automatically.
The thing is that
we are drawing the attention of the court for that. It's not automatic.
And another aspect, while I was arguing that the number of matters was placed before my Lord Justice, Chief Justice, and I raise a point, I have something different to argue. That's why matter was adjourned by my Lord Chief Justice. And thing is that this honorable court and Supreme Court has also held that it cannot be automatically dropped. It's a prosecution of a special statute.
That has been taken
out. It will create it. No. Jo Minakatan Pani is not a PC Act offense. Another aspect is we are covered by a special statute.
We are concerned about the law, not the PC Act, not the vigilance, not crime branch, not ED.
Shall I reserve the judgment? You will give written submission?
Yes.
No, but it requires a thorough hearing because it creates a situation like that Asian resurfacing case.
Vigilance is nothing something.
Then why were you reading to?
When do you want?
Let it come after vacation so that It will be argued. Number of cases will be, every after that Minakatan Panish judgment. Now they are picking up their inquiry officers and
Not
getting
picking up-
exonerated there.
picking
And
up
you
their
lordship can visualize.
Here the-
What
sort of allegations?
How accused can?
No, no. My submission is let it be tested. Let it be tested again by the Honorable Apex Court also. We want also
Till
that.
then, he will move an application and.
That point that has been taken note of, I have quoted for that reason, paragraph 13, my let me see. The CVC note, from our point of view, 38(7) is important, and the High Court had bothered to apply this parameter. Then reading of CVC report on the same fact, the appellants should have been exonerated. Applying the aforesaid judgments of the facts, it is clear that in view of the detailed CVC order, they are also mandatory vigilance case.
Right. Right. Okay. And Mr. DP, the Senior Counsel, submit that he would move application before the court below seeking adjournment. Owing to the fact that the matter is reached.
Because we want it should be retested.
And if these are all these cases, you give one.
Yes, there should be.
And there are cases.
One date we will hear. And
distinguished ballot, it's a elaborate. If ballot will go through the judgment of Minakatan Pani.
Minakatan.
I have dealt with Minakatan in one of the matters.
Kejriwal judgment that was referred in the Minakatan Panish judgment. Minakatan, that the law is also settled there. The finding of the departmental proceeding is not binding.
See, Radhesham is
Radhesham Kejriwal.
Radhesham is adjudication proceeding, not departmental proceeding. That's the distinction. That's the distinction.
This
In those old days, that those FERA cases and all, adjudication proceeding, you are exonerated. Then in criminal prosecution is automatically dropped. That was the law.
But it's not the departmental, my lord. Your lordship visualize. In a DA case, they will file a representation, he will be exonerated there. And the criminal proceeding will go. And are they competent too?
Oh, anyway, we'll
I want, with all respect, let it be tested.
Okay, these are
let it be tested because every.
Since there is a judgment now.
Judgment is there, my lord. I have verified.
Minakatan is there.
No, after Minakatan, my learned friend says Supreme Court has passed the judgment. I don't think any judgment.
In the case of Minakatan, we will have to examine all these.
My lord.
And all the similar matters, you give a particular date, we fix and.
Better one.
If you have a case,
my learned friend is there who day in and day out.
also have some cases. You give the date, let us fix and.
Let it be
settled for all times.
Fix it at 2 o'clock.
Let it come after. I want also, let it be tested again.
That's what I'm saying. All the similar cases, you know.
My lord will fix up this case to 26th June.
26 June. 26 June.
That is
and give all the numbers.
Can it be on 28th June? 26 शुक्रवार अच्छी सॉरी शनिवार रविवार छुट्टी है
28 no problem. But give the number of all the cases to our court master. He will list all the matters on 28th.
नहीं के सेपरेट अलग अलग अच्छी सब they are
different but
point of law is so far as the application of point of law is concerned that the
we are deciding point of law only.
Yes. So class case of case to case basis is to be stated.
Point of law to decide कर दो.
28. This case may be also be adjourned.
Yes, sir. 32.
Lordship, rejection of an application for sending a document to the expired is being rejected and that is being impugned. The fact leading to this application is that a case for demand of bribe was registered against me. And it is stated that for detection of the demand of bribe, a trap was led by the Vigilance Department. And the trap was led, the money was recovered, I had received the money. My defense during the trial is that the concerned person had taken a loan from me and returned that amount to me on that date. So I don't dispute the receipt of the money. The only question is whether I had received this as a loan or as bribe. That is the question for determination. While the complainant was examined, I put forth to the complainant a promissory note stating that, look, this is the agreement you had made, a promissory note you had executed, stating that you have taken the amount as a loan from me. And the complainant denied that. Immediately after he denied, I filed the application before the court stating the court that the document be sent to the handwriting expert for opinion. And the learned trial court has rejected it. That's the crux of my defense.
Yes, Mr. Mohan.
So at this stage cannot be, the defense was a 243 रे से देबे ना, एबे कौन दे-
293 रह गया at any stage.
If it goes to the root of the matter,
नहीं, root of the matter काहे की नुए, your lordship kindly visualize. Thing is that now the trap was laid. No such immediate explanation was given that I have taken in that is the money in respect of that loan. Loan 10,000 ଦେଇଥିଲି, ବର୍ତ୍ତମାନ it's created the document under the face of the record. On the face of the record, court is also competent to verify the signature, and court was not satisfied. And in the worst case, if at all it is their case, that it's a case of defense and it is document.
what is the prejudice to you? He
Prejudice
is
only to,
right.
only to linger the case.
We want to
No.
Only to linger the case. That is
Linger
not-
तो होगा वो defense stage रे file करे और linger होगा.
Immediately, if you want to prove that document either here or there, it will take the same time.
So far as the case is concerned, the court is also.
Where is the impugn order? What are
Impugn order, your
the
lordship
reasoning?
kindly space 20.
20. Reasoning क्या है?
Last 4 to 5 line. During cross-examination of PW3, your lordship got it.
Last order.
Last 6-7 line from the 20.
Here.
During cross-examination of PW3, it was suggested by the defense that on 30/2 in presence of the nephew of the accused, the complainant took a hand loan 10,000 from the accused and that he had not repaid the said amount on the date of trial. He gave an amount of 7,000 by giving him the impression that the said amount was towards the payment of part payment of the loan amount of 10,000 and that he had issued a hand note in this regard, but the complainant denied the suggestion of the defense. The alleged hand note and his alleged signature appearing.
If you say that it is created subsequently, the complainant would have supported him. Complainant is not supporting. The very fact that complainant is not supporting,
My lord.
it goes to show that this document needs to be gone.
Your lordship then come. It being shown the defense of the complainant, he denied its existence and signature thereon. The alleged complaint.
Yes.
It's a suggestion.
Yes.
And the alleged hand note is marked as X for identification. On perusal of record, more particularly the detection report under Exhibit 8, it reveals that the accused has not put forth this plea at the first available opportunity. That is at the time of detection and seems to have been evolved a new story at the time of examination of PW3. Other witnesses like TLO, IO are yet to be examined. The prayer for collection of, he could have produced that document during investigation events or so on. He has not produced only.
You know the IO, what the IO do.
I have
Any document which are genuine document produced by the accused is they ignored.
Again, se tapaka jo se document tha se aji pon rahithanta ebe astino thante
I have the right to silence before the IO.
What is
Right.
wrong in it? What is the prejudice causing?
wrong kichi na wrong hochi the attempt of the accused to exercise its right under section 243 2 of the CRP is prematurely, which is impermissible in law. At the premature stage, the document produced by the accused cannot be accepted. That's why it has been rejected. Let it come and it will be tested. If it will be tested, the trial court is also competent to see in the naked eye if it is comparable. It's a
Where is
signature.
that promissory note?
243.
Where is that? Have you filed it? Yes.
243.
Copy of
No, se lekhichen se tang judgment order re lekhichen. Impugned order is
I want to see that promissory note.
243. That the defense
Where
of
are you searching in the book? I'm talking about the promissory note itself, that document itself.
document they nahi.
Document. Do you have that document?
No, I don't have. The
document
document
is
is
there
there
to
in the record. It has gone to the
I
trial
just
court
want to see-
record.
I just want to see.
No, I will have to obtain the certified copy.
देखिए यदि मिसी होता है
But my learned friend stated about two things. My learned friend stated that the occasion comes when you enter 243.
Right.
That is a defense. That is what he argued. Lordship may kindly seeks 293. The document is there already in the record. It has gone to the record. And 293 section says that the court is competent to ask for the scientific opinion from the commission or by issuing commission. The court is competent at any stage during the inquiry or trial. Section 293 NP says. So exercising the power under 293, the court can. Then secondly, my learned friend stated that I had not taken the defense before the IO. I have the right to silence before the IO. That is my constitutional right. I need not tell my defense to the IO.
That is not the section 7.
No, no.
It's a
PCI
draft case,
is
he
not
has to
able
give
to.
immediate explanation.
I reserve the judgment. You say whatever you want to say.
Lordship.
Okay. Give in writing whatever you want.
Within 2 days?
2 days. Yes. I just come.
Document dele bhi, your lordship can also verify. Jodi misuthba wala, otherwise it can, your lordship can send it. It the purpose will serve. Let him file that document. Photocopy of that document, it can be tested.
If you can.
There is no judgment or abasyakata kichhi nahi.
Expert, the court is not a scientific expert. Although there is provision that the court can compare.
Court is expert of experts.
Court does not have the knowledge about the fingerprint and the comparison of documents. Those are two.
Okay, I'm reserving it.
Scientific.
I'm reserving it. You just keep two page note. You also keep.
Lordship.
Yes, ମୁଁ କାହିଁ କହୁଥିଲି କି unless we are entering into the arena of that controversy, there is a copy ଟା ଦେଇ ଦିଅନ୍ତୁ ଯଦି ମିଶିବ ବା ନ ମିଶିବ lordship can also send and direct. Sorry, problem.
See, in a case of this nature, two things has to be proved by defense: demand and acceptance.
That I know.
Acceptance is
Lordship. Lordship, one thing I am telling. Lordship, they say that the document do not match. That is what they say. The report will come in their favor. That it does not match.
Dispose of
that it does not match.
I need not argue these.
Yes, Lord.
I'll allow it. Okay. I'll allow it.
সেটা নন অ্যাপিয়ার সেই দিয়েছি
small prayer or infectious age infectious age.
Why infectious?
Because my lord, that 7 witnesses, my lord, has not been cross-examined till date by this defense. For that reason, I have filed this application.
Then it was so urgent that you should have been here.
ଆସୁ ପଡିଗଲା ଆଜି ଟିକେ ସ୍ପିଡି ଅଛନ୍ତି କୋର୍ଟ ବହୁତ ସ୍ପିଡି ସେଇଥିପାଇଁ ଆମର ଏକ୍ସପେକ୍ଟେସନ ବିୟଣ୍ଡ ହେଇଗଲା ଟିକେ
I may be pardoned, my lord. Item number 12. I do not object for the adjournment, but my lord, but just not appearance.
What is this method of mentioning in between?
My lord, I may be extremely.
Then we'll see.
My lord, just non-appearance, my lord.
No, non-appearance cut diyo. 12 years. I can.
Highly obliged, my lord. Highly obliged.
Mr. Mahapatra appear.
Highly obliged.
Yes. 33. And there are few matters settlement matters. The parties are
11.
5 minutes. Okay.
33. Lordship, I am for the petitioner.
Yes.
Lordship, I am challenging the order dated 22/11/2040, the issuance of the non-bailable warrant and order taking cognizance and quashing of the entire criminal proceeding. Lordship, the fact of the matter is the petitioner is a
three prayers in one application.
One application, Lordship. Yes. Lordship, the fact of the matter is the petitioner is an old, ailing person. He's unable to walk. The excise officials on 14th, 2014, they have raided his house, but the petitioner was not present. And the petitioner is not having an exclusive possession right. ସେଇଠି ତାଙ୍କର ଦିଟା ଭାଇ ଅଛନ୍ତି ତାଙ୍କ ଦିଟା ପିଲା ଅଛନ୍ତି Lordship may have a glance at the page 5 The plots are central lands of Dolo Govinda Sahu, who is the father of Gati Krishna Sahu, who is a present petitioner, and Kailash Sahu, and other co-heirs, namely Balaka Sahu, Bhagirathi Sahu, who was the son of Burdaman Sahu. So it cannot be said that petitioner is having an exclusive ownership of that land. And that day, when the excise official with the police,
How will I?
It will be tested in this.
Lordship,
How will I go into all these things, the stage of cognizance?
Lordship, and they have booked the petitioner. Petitioner is staying at Calcutta with his son. He's an old man.
Maybe you have some logistical
Lordship.
problem you may be having, but how can I help you? I can only quash the NBW.
But this is a
And
case
tell
of.
me, tell me when you can appear and
Yes.
seek your remedy.
Yes.
Lordship,
As much as time you want.
2 months time, Lordship.
ହଁ ହଉ ଜୁନ୍ ଆମେ ତ ଜୁନ୍ 30 କି ରଖୁଛୁ
June 30 to AGP I am giving.
ଏମିତିରେ ଆମେ ରଖୁଛୁ
30th June. If you want further time, you move application, I'll extend it. Okay.
Lordship.
Yes.
Because he's an old man, Lordship. He's 70
I
years old.
understand it, but
And he came to know from a local person because none of the witnesses are there.
you are on bail.
No, Lordship.
No.
He
Absconder
doesn't.
since 2013
Lordship.
absconder since 2013
Lordship.
in 2014 NBW issued
Lordship may have a glance.
Request of you.
no charge sheet filed showing him absconder
Lordship may have a glance at annexure to page 11. There he has written in the final charge sheet, the accused was not present at the time of the seizure.
yes
This excise obsolete because he is staying at Calcutta. He doesn't know what is happening at his house.
Anyway, you appear. Right now. Where is the NBW order?
page 16
16, huh? Petitioner is an accused in fire number 2. Charge sheet was filed in this case on 19/12/2013, showing the petitioner is an absconder. Subsequently, on 22/11/2014, which court has issued this? Special Judge Ankur issued NBW against the petitioner. Next one. The petitioner is challenging the criminal prosecution initiated against him, and also the order dated 22. This is order dated 22/11/2014, whereby NBW has been issued against him. Insofar as the challenge to the cognizance order and cognizance order also you are telling me? Cognizance order and the entire criminal prosecution is concerned, the petitioner is not reaching the petition at this stage and reserving the right to approach the court below at the later stage. Insofar as the issuance of NBW is concerned, on instruction, when counsel the petitioner submit that the client will be appearing before the court on or before 30th of June 2024 and avail all remedy under law, which is taking into consideration the submission made to the bar. The NBW issued against the petitioner by the organization and be kept in level till 30th April. Subject to the action that petitioner shall appear before the court and seek remedy availability. Allowed.
Published.
Yeah. Here. 11. 11. Yes. Yes. Just see, Mr. Maharaj.
yes yes
498A.
yes
Husband wife are present. I am appealing for
13B application is pending before the court
pending. That is not pending. Argument over. It is
Anyway, they
delivery of the judgments.
yes.
so pending out
Permanent alimony has been paid. Where is he?
and wife and husband is present
Yes.
others are absent
Call.
asandu
And the government council is misconceived. The address is, the first address is the address of the husband, in-laws. They say a daughter of Aditya Kumar Swai, occupation service, resident of village Harishpur.
18, huh? Item 18. 88. 88.
88.
Yeah.
So notice were served and neither it is written nor.
You tell me you have settled the dispute.
Pardon? Yes.
So then you have to bring them. Simple. Why are you depending upon
No, my accused is here. But after resolution of marriage, wife is residing at Calcutta.
ଆପଣ କାହା ଆଡ୍ରେସ ଦେଖିଲେ କୋଉ ଆଡ୍ରେସ ଯାଇଛି ଚିଠିଟା
फास्ट जाइथिला तार प्रेजेंट एड्रेस रे सेकंड एड्रेस टा आपण कहिले जे ए जो रेसिडेंट ऑफ हरिशपुर इज द एड्रेस ऑफ द हस्बैंड
No, no, no. At present, resident of ships of the apartment, Debalpur near Durga Mandira.
सेटा तो फर्स्ट इंस्टेंस रे फेरी आसिला नोबडी इज रिजाइडिंग देयर
Permanent address रे?
permanent address is not given permanent address what my learned friend means that is the address of this accused daughter of Aditya Kumar Singh
Where is their dissolution of marriage judgment? Where the
annexure 3 my lord 21 page
20?
annexure 3
Show me where it is recorded that you have paid the alimony and all.
in the cost title the
Forget
address
about
is
that. You tell me where have you paid the alimony?
21 page 10 to n
21.
yes
Yes. So
Srimati Sangeeta Swain alias Pal aged about 30
I'm asking something. You are reading something.
Pardon?
You have paid the permanent
Permanent alimony ta kodi
to your wife. Where will I get?
I don't no claim for permanent alimony
Where is that? Show me.
Yes.
There is no claim. She made no claim.
it is page 26
Huh?
page 26
Right.
both petitioner have mutually decided and agreed that they have not interfered in the private life of
Where are
this
you
one.
reading? Where are
Petitioner number has agreed that she shall not claim anything.
you?
Page 26
26. Which para?
last part. She shall not claim anything from the petitioner number 2 in future.
Then I'll pass it. Oh, Mr. Mala.
No claim regarding any permanent alimony or future maintenance
Right on.
from petitioner number 2.
At the instance of opposite party number 2, FIR number so and so was registered with the petitioner. The dispute is arising over the matrimonial dispute.
Yes.
The parties have settled the dispute and applied for 13B. This is 13B.
13B filed by
For
DB.
resolution of their marriage under section 13B of HMA. The family court, family judge
Sambalpur.
Wide judgment dated
Judgment dated 29/3/2022.
2022 in civil proceeding number 33 of 2022 is allowed the petition allowed the petition and dissolve the marriage of the petitioner and respondent number 2 by mutual consent. In the 26 you have shown now,
Yes, 26.
while allowing the pray for resolution of marriage, the court below has recorded as under.
Sign करो दो.
Page
अगर sign करो.
Page 22 para. It is also brought to the notice. Page 26. You look, see parata ke look. It is also brought to Pura Lindo. Notice was issued to the next one. The petitioner is seeking quashing of the FIR and consequential arising therefrom on the basis of the state. This court by the order dated 26/6/2023 issued notice to the opposite party number 2. Opposite party number 2. Despite sufficient notice as recorded in order dated 26/4/2024 of this court, the opposite party number 2 has not appeared. And consequently, the petitioner submits that the opposite party number 2 is not interested in the proceeding. He has already settled her life in Calcutta, and she is not willing to appear in this matter. Despite repeated efforts made by him and effective service on him on her, and she chooses not to appear before this court. Therefore, on the basis of the settlement arrived between the party, which is reflecting in the order of the family court while granting while dissolving the marriage by mutual consent, the present petition may be allowed and the FIR and consequently may be.
Proceeding, it has started.
Good. may require. Mr. Maharaja appears from the state submits that indeed notice was issued to opposite party number 2. And in the order dated 26/4/2024, this court has recorded that the notice is sufficient, relying upon the judgment of C.T. Albi Haji versus Palapeti Muhammad and others, reported in 2007, 6 ACT 555. So therefore, it should be treated as if the notice was sufficiently served on the opposite party number 2. Insofar as the settlement part is concerned, the terms of settlement is reflecting in the order of the family court while granting the divorce by mutual consent. The same may be taken as the terms of settlement. In that view of the matter, there is no legal impediment in passing the taking into consideration glancing and so on and so forth. Yes.
130.
130.
130. Yes.
Hello, in this case, altogether 3 accused persons, my lord. This matter has been compromised so far the petitioner is concerned. Both are additionally added on the basis of a complaint petition filed. Page 10, your lordship, kindly see the order sheet, my state, my lord. There are additional accused, my lord. So far the principal accused concerned, they have not been settled, although matter has been settled in respect of the petitioner, my lord. This petitioner are additionally added in the complaint petition. The both matters have been tagged by the magistrate. Page 10, lordship, clarify, lordship, kindly see page 10. The order of the
I
magistrate.
want to say that in so far as these two
Petitioner is concerned, there
he is settled.
Settled, my lord.
What about the other accused?
The principal accused, my lord, who has been, my lord, the land has been sold to the petitioners, my lord, by making a, my lord, false, my lord, legal error certificate.
No, that can't be.
Huh?
Partial
choose. Who are you to choose?
You can't.
You don't have any right to choose.
5 accused persons are there.
Yes,
you will
my lord.
choose 2.
They are additional. My lord, they are not charge sheeted accused, my lord. They are not charge sheeted. They are not charge sheeted accused, my lord.
Either the entire proceeding has to be quashed.
Well, there are judgments. Judgment of the Supreme Court as well as the High Courts, my lord, different High Courts, partial compromise can be done, my lord.
With the compounding.
Yes, my
lord. Compounding.
Yes, my
you
lord.
go and move application. Then the compounding offense can be done.
No, High
What
Court,
are the terms of settlement?
Settlement terms of settlement, my lord, because there has been the
I like them and I don't like
no,
others.
no, like them.
So what is the term?
Term because the money has, they are the purchaser of the land. The petitioner's share has been purchased by these petitioners. They have returned the money to the petitioners, so matter has been compromised.
Just
Yes.
examine.
Different High Court judgments, my lords. The Telangana High Court, the Delhi High Court, lordship.
Okay, kali pe rakho.
Yes, my lord.
Upon Mr. Maharaj will examine whether it is legally permissible or not.
Yes, my lord.
Because it is a dispute
regarding
some land.
Land, my lord.
Money is taken.
There, my lord, there are 2 shareholders.
Why are you not settling with others?
Because he did not come, my lord.
The accused persons are.
Not he is the one of the legal heir, but he did not come. They are the purchaser, so the payment they are share person and they have been compromised. My lord.
It will not affect the trial.
No, my lord, because they are not original charge sheeted accused, my lord. They have been additionally added, my lord.
Whatever. I'm passing for these people.
Yes, my lord.
How can we proceed against the other? Yes, examine it. We did one. Yes, next. We will not waste much more time. Yes. Come to.
Can I, my lord, submit before this court, my lord? The judgments, my lord.
Tomorrow. Tomorrow, satisfy, give the copy.
Yes, yes.
I will. The assistant would be there tomorrow. Yes.
34. Continue, huh?
Yes.
In this case, last time, my lord has directed the petitioner to move before the lower court. Accordingly, I moved before the lower court, and accordingly, lower court has granted bail application so far the petitioner is concerned. And so far the quashing of proceeding is concerned, one my friend has appeared. So far 2 is victim. So notice has to go.
Issue notice to opposite party number 2.
Because I was in jail custody.
Oh, let us see. Issue notice to opposite party number 2. Yes. Next.
35.
And in this case, already evidence has been also closed.
I have issued notice. Yes.
On behalf of Mr. Mishra, a short adjournment may be given by
Yes, urgent.
36.
obliged.
36, my lords, I pray for a passover.
No passover today, sir.
My lords, my senior Mr. Kanungo is on his legs in another.
Today may not be possible.
My lords, may keep it to tomorrow.
End of the board. If at all it will end today. End of the board.
I understand your lordship's constraints. My lords. No.
37.
End of the board, huh?
My lords.
Come after 4 o'clock.
My
Yes.
May it please the Lordship.
So, sir.
Lordship, may it please the Lordship.
Yes.
Lordship, may I be permitted to place on VC Lordship?
Sorry?
May I be permitted to place on VC Lordship?
Yes, of course.
Yes, Lordship. Lordship, the petitioner has challenged his default bail has been rejected, for which he has preferred this application, Lordship. Lordship may kindly have a glance at page 19, annexure 1. Third paragraph, Lordship.
Yes.
On perusal of the case record, it is found that the accused was taken to custody on 7/4.
Where are you reading?
Annex page 19, annexure 1, Lordship.
19, okay.
Order in
Yes.
question, Lordship.
On
Para
perusal,
3,
yes.
Lordship. On perusal of the case record, it is found that the accused was taken to custody on 7/4/2022, and the charge sheet should have been filed within the stipulated period of 180 days, which was complete on 3/10/2022. As it appears from the order sheet on record and documents submitted by the advocate for the accused, charge sheet is submitted in the month of November 2022. Even though the charge sheet is dated as 2/10/2022, so it is not in dispute that the charge sheet was submitted beyond 180 days, and indefeasible right of the accused did not arise on 4/10 to go on default bail. It is unclear from the record whether the accused was intimated or not of his right to default bail, as the case record has not been put up on the date fixed, that is 5/9/2022, thereof till filing of the charge sheet.
So it was filed within 180.
No,
No.
Lordship.
Now
Lordship,
here,
the
Lordship, may
order-
kindly see.
Order sheet, Lordship,
While
may kindly have a
the
glance at the order
quantity,
sheet.
yes. I got your point.
Yes,
The quantity is 1,537 kg ganja. It's a man of Rajasthan. This petitioner has moved on bail application before this honorable court. And this honorable court, after 14 adjournment of the petitioner, granted interim bail. Or some can see.
Yes.
Thank you. Neither the petitioner nor his conducting counsel has ever raised this point that the petitioner is entitled for default bail. This is one thing. So far, the point of law is concerned, when his individual right has not availed, automatically it will extinguish after filing of a charge sheet. That is the law decided by court not bench.
Lordship, it is the duty of the court.
That
It
is
is
the
the
law.
duty of the court to inform the.
After 1 year, 4 months, this point has been raised for the first time.
Lordship, in the previous the bail application, I was.
You don't have a case, what to do?
Lordship, may I adjourn this matter? I will satisfy your Lordship in that point, Lordship.
I adjourn. You withdraw it and move application. For
Lordship,
bail.
I will satisfy. Lordship, may I adjourn this matter to some other day? I will satisfy your Lordship.
Yes.
38.
As it is filed within 80 days.
My Lordship, Lordship, may kindly have a glance at the order sheet, Lordship. That is at page 68, Lordship. Lordship,
Anyway, I'm simply adjourning.
Yes, sir.
38.
That order may be taken on record.
This one?
Yes, yes. This one.
That lose record. Problem with.
Yes.
Yes.
38.
38.
38 ରେ କିଛି ଦେଇନାହାନ୍ତି, ଖାଲି ପିଟିସନ ଟା ଦେଇଛନ୍ତି। ଆପଣଙ୍କୁ ଦେଇଛନ୍ତି କି
Same cognizance of.
ନାଇଁ, କିଛି ଦେଇନାହାନ୍ତି। ଆମକୁ ଖାଲି ପିଟିସନ ଟା ଦିଆଯାଇଛି।
ଯେ ଆଇରେ ବି ଫାଇଲ କରିଛି ଗୋଟେ cognizance order, nothing else.
Okay,
What's the cognizance without filing? Except the order of order dated 11/11/2022 by which the court below has taken cognizance for offences, no other document has been filed in this petition, challenging the order of cognizance. To leave the order of cognizance.
And no order also filed before the state.
In the absence of any documents, this matter cannot be decided. Leave the matter in the other.
And
39. Wait, vigilance. Here, where the petitioners have challenged the order taking cognizance passed by the land magistrate. So, including taking cognizance for offences punishable under sections 419, 465, 468, 471 to 94, 506.
Yes.
Well, before filing this complaint petition under Annexure 1, well, the complainant had filed a civil suit. Well, let me see Annexure 4. That was in the year 2015. Vida Thappa versus Somnath.
What are the allegations?
Allegation, my lord, with regards to property dispute between the parties with regards to sales, purchase.
One property or many properties involved?
Some properties.
You have developer.
No. But immediate neighbor. Sonpur, immediate neighbor. My lord,
it is an isolated
in fact, well, what has happened?
Property dealing, or you are involved in property dealing work?
No, my lord. See, he says, I have impersonated myself as X and sell some property which belongs to her. And for that reason, a case was registered earlier under Annexure 5,
Yes.
where trial was conducted, and under Annexure 7, I have been acquitted. Again, after acquittal of this case, this present complaint case. But let me see Annexure 7.
You have a very good neighbor. What to do? Will you settle it? Why don't you settle it?
Let her come married here because
I just
it
think
will
you should
dispute.
settle it.
Yes.
Suit is pending. One FIR was investigated. Investigation is closed.
Yes.
Thereafter, one complaint. What is it?
Yes, sir. It's a very good case.
I'll just issue notice letter.
Yes. And stay also.
Hey.
And that is her own sole intention is this. Ballot will fix up a date so that she can appear through lawyer or it can be sorted out.
I will. What I'll do is I'll stay the proceeding and I'll send you to mediation.
Yes.
It can be good.
That's the only way.
Yes.
Otherwise, I can't justify stay.
Right. It should be.
Isn't it?
Local mediation, man.
Where you tell me where?
Sonpur.
District Court. Right out. The dispute appears to be essentially a civil in nature. Earlier FIR was FIR number. What was the FIR? Earlier FIR.
Earlier valid that is
FIR PS case number. PS Sonpur.
PS
case number
55 for 2019.
19 was registered against the petitioner, and eventually after trial, the petitioners were acquitted. Petitioners were acquitted. Thereafter, the present complaint is filed.
Yes.
Present complaint is filed.
Yes.
There is a suit pending between the parties.
By civil suit number 173 of 2015.
By civil suit number 173 of 2015.
For the civil just senior division, Sonpur.
Taking into consideration the peculiar facts of the present case, I am of the considered view that the matter could be settled through mediation. Therefore, the parties are relegated to Sonpur District Mediation Center. What is that name? Really? What is that? Mediation Center. District Mediation Center.
DLS.
District
Legal Service Authority.
District Legal Service Sonpur. To explore the possibility of settlement. Issue notice to by fixing a particular date. Right out. उसके बाद issue notice to opposite party number 2, Mr. Maharaja accept notice for state.
Yes.
State, and in the meantime, further proceeding in so on. Yes.
Item 40.
Yes, what is this matter?
Sir, quashing of FIR, madam.
dated 15/2/2024. FIR is recently, my lord, 15/2/2024.
Investigation is on.
Investigation is on.
Or the year for this June to go. Urgent. In the present petition, petitioner is seeking quashing, none appears for the petitioner. In the present petition, petitioner is seeking quashing of the FIR. Registered on
15/2/2024.
15/2/2024. So the investigation is still going on. Urgent 2.
My lords, item 41 for compromise.
41.
My lords. Sub item.
Next item is 41?
Yes, 41. Next one, I think 41.
Yes, 41. Yes.
For compromise, my lords.
Yes.
Compromise.
After time bangle. After vaccine age, approve ratio.
15 रे आसो my lords.
Aswe. Both party.
What is the offense?
My lords, offense
307.
307.
Injury report
Simple
and
injury.
My lords.
After vaccine age, first time आउतले सेटा subject
All are released on bail, my lords.
Local like
15.
लोग आने में injury report आने में है
Injury report and case.
My lords. My lords.
Yes.
42.
CMC number 128 of 2024 arising out of no case number 55/24 and dated notice dated 28/3/2024 minor kind see unnecessary 1, my lord. The allegation against the present petition, my lord. Paragraph 2, my lord. Page 9, unnecessary 1. The ability of the general reports of the society reported.
ये केस है किसी नहीं 110 रे अपन जीवन ने
allegation format allegation
कौन allegation
Only show cause not to go and
allegation against kind see minor allegation against the president. He is addicted to liquor tablets and forex. The always taking liquor, my lord. This is the allegation of the present petition.
Don't take liquor.
No, my lord.
Don't tell that I will not take liquor.
ଆଉ ତା ପୂର୍ବରୁ କିଛି ପଡିଲନି ସେଇଟା ପଡିଲା ସେଇଟା ମୋ ପାଇଁ
ସେ ଗୋଟେ ଆଜ୍ଞା କୌଣସି ଡେଟରେ ସିଙ୍ଗଲ ଡେଟରେ ସେ
You were summoned. Go and tell that I will not take liquor.
ଏ ମାନେ ହଉଛି habitual
no
many cases are pending
present
ଆପଣ ଯିବେ ଶୋ କୋଜ ଦେବେ
ଶୋ କୋଜ ଦେଇଛି ଆଜ୍ଞା Annexure 3 ମୁଁ ଗୋଟେ social worker president ବିଭିନ୍ନ organization president
President की ପିଉଛନ୍ତି ଆଉ କଣ?
ନା no ମାନେ ସିଙ୍ଗଲ ଟାଇମ କୌଣସି ଜିନିଷ ମୁଁ ପିଏନି କି ପାନ ଗୁଟୁକା କିଛି ନାହିଁ ଆଜ୍ଞା କିଛି ଖାଏନି
ରଘୁ ଦୋକାନ
ଶୋ କୋଜ Annexure 3 ରେ ଦେଇଛି this is the allegation ମାନେ କାହିଁ ଆମେ ପଚାରିଲା ନା ନାଇଁ this is the formal ହଉଛି format ଅଛି ଆମେ this is the format.
Okay, you have given show cause. Where is that?
Annexure 3, my lord.
3.
Annexure 3 Annexure 3 paragraph 2 the president holding the post of president of Janamanto Civil Society.
Okay, I understood. Pursuant to the notice issued to the petitioner under section 110 CRPC, the petitioner reply dated 5/4/2024.
ଏଟା ତାଙ୍କ ହାତରେ ନିଜେ ଲେଖି ଦେଇଛନ୍ତି ଆଧାରେ କିଛି
ଦେଇଛି ଆଉ କଣ
କୋର୍ଟ ଦେଇଛ କହୁନ ଆଧାରେ ଷ୍ଟାମ୍ପ କାହିଁ
ଆପଣ ଏଠି ଦେଇଛି ବା ଏଠି ଆପଣ ଦେଇଛି ଏକ୍ଜିକ୍ୟୁଟିଭ ମ୍ୟାଜିଷ୍ଟ୍ରେଟ
ତାଙ୍କ ଷ୍ଟାମ୍ପଟା କୋଉଠି ଦେଖେଇଦେଲେ ତାଙ୍କ ଷ୍ଟାମ୍ପଟା କୋଉଠି ଦେଖାନ୍ତୁ ଏକ୍ଜିକ୍ୟୁଟିଭ ମ୍ୟାଜିଷ୍ଟ୍ରେଟ certified copy
arising out of the notice proceeding proceeding wide CMC number 128.
Annexure 1.
You have written something 55 something. What is this?
My lord, 128 of 2024 arising no FR number 55 of 2024 improved notice dated.
What have you written in handwriting? What have you written? No
FR, my lord. Can you see page 9? Page 9 Annexure 1. Patna of PS non-FR number 55. 55 over 2024. Page 9. SDB of Patna FR.
The petitioner has already given the show cause. The same may be considered by the company.
Yes.
With this observation, the petition.
Well,
43. Next. There, yes. Sir. Yes.
May I please your lordship?
Yes.
My lord, here, this trial is arising out of a FIR under Annexure 1. The case is being tried by the Special Court, Women's Court, my lord.
Yes.
The requirement of the law is for speedy trial. Accused is in custody. Since, my lord, January 2024, my lord, more than 10 dates have been given to the victim for adducing evidence. Every date when the trial is date is posted.
Who are you?
I am the accused, my lord. I am the accused. I am suffering in the custody, and trial is the victim is taking adjournment. Witness, victim taking adjournment.
Where is the proceeding?
My lord, proceeding before the Nayagarh, my lord,
where
Women's Court, Nayagarh.
You show me the court proceeding.
My lord, Annexure 2, page 18. Your lordship may kindly see. After framing of the charge, the case is posted for trial, and since 10/1/2024, the accused is taking adjournment. Sorry, the victim is taking adjournment to
That's why I'm
adduce.
confusing. Therefore, I asked who.
No, sorry. I am for the accused.
You are saying accused is taking.
No, my lord. Victim is taking adjournment. My lord, more than 10 dates have been adjourned, my lord. The court is not taking any steps, my lord. And when I filed an application to at least ensure his appearance.
Don't you think that there's good ground for getting bail?
No, my lord, because a precondition has been given by this honorable court once the victim is examined.
Okay.
Therefore,
Where is that?
My lord,
Where is that order?
That order I have not annexed, but I have quoted that order, my lord.
Where is that? Where have you quoted? Right. Where have you quoted, sir?
My lord. My lord. Para 4, my lord. Para 4.
Why are you not filing this?
My lord, sorry, my lord, because I do not have the certified copy. That is why I could not file it. My lord, I am passing the order, my lord. Passing the order of this.
He had applied for bail before this court by filing AVPL number 112.
My lord, BLAPL number.
BLAPL number 2023. Okay. The ordinate bench of this court rejected the bail application and granted liberty to the petitioner to revive the plea of bail after the examination of the victim guard. Next part. The grievance of the petitioner in the present petition is that the prosecution is not moving at all, and the victim, on behalf of the victim girl, adjournment is sought repeatedly.
Since 10/1/2024.
Since 10/1/2020. 24. The petitioner is in custody awaiting the examination of victim girl. Therefore, he seeks indulgence of this court for a direction to expedite the process of examining the victim girl. He is relying upon the proceeding of the court below, which reveals that the matter is being repeatedly adjourned for recording of the for examination of the victim girl. In view of the aforementioned, I'm inclined to allow the present petition and direct the court below to do well to see that the victim girl is examined as early as possible without unnecessary adjourning the.
My lord, date is fixed to, my lord, date is fixed to 17, let it be on
I
17.
will not see it.
Sit in
17th,
there,
I
sit
don't
there.
know exactly, but I have given that much indication.
Uh,
Without adjourning unnecessary.
Yes.
This is
My lord, may observe that the victim girl may be examined.
That's
Lekha,
what
lekha.
I- without
That is
it, unnecessarily adjourned,
Adjournment.
victim girl will be examined. Thereafter,
And the trial be completed within 3 months. My lord.
trial I'll not.
সেটা কেন দেবো
Trial I'll not. How many witnesses, I don't know.
My lord.
Yes.
বহুত প্রবলেম হবে
My lord.
Disposal, yes.
44.
My lord,
My lord, I am preparing on behalf of the
Don't do that, sir. After lunch, you mention if you have any. Yes.
My lord, urgent copy, my lord. Since the matter is on 17th. My lord.
Urgent copy, subject to condition, they should type it. Today you'll get it.
My lord, is my.
My lord, I am preparing on behalf of the petitioner.
Yes, sir.
And this is a matrimonial dispute. The petitioner and the opinion number 2 is the opinion number 2 is the wife of petitioner number 1 and
What do you want? What do you want, sir?
I have filed the quashing of charge sheet along with the convenience order of the convenience passed by the landlord lower court. Both the party has living peacefully since long, and due to the aggravation of the other person, the petitioner
This is a matrimonial dispute, it appears, and you have settled your dispute. That's what you are saying.
This is a matrimonial dispute, and the opinion 2 has filed a application before the DLSA Bolangir for settlement of the matrimonial dispute. Apart from that, she has filed another petition before the
Okay, I'll simply issue notice, settlement will be.
So I
ସେ ଗୋଟେ ଆଣ୍ଟିସିପେଟରୀ ୱେଲ୍ ଫାଇଲ କରିଥିଲେ ତାକୁ ନୋଟ ପ୍ରେସ୍ କରିଛନ୍ତି ଗୋଟେ ସିଆରଏଲଏମସି ଫାଇଲ କରିଥିଲେ ତାକୁ ଉଡ୍ର କରିଛନ୍ତି
Now he says
Certificate ଦେଇନି
I'll simply issue notice.
Yes.
Issue notice.
So, sir, I have prayed for stay the further proceeding of the.
ସେଇଟା ତ
problem.
ଖାଇଲା
You have filed
କେବଳ
two application which is
ଏଥିରେ ଅର୍ଡର ପାଇନାହାନ୍ତି ବୋଲି ସେଟା ଏଇଟା ଫାଇଲ କରିଛନ୍ତି
My lord, kindly peruse the annexure number
petitioner
9.
out of a matrimonial dispute, and there is the parties are settling the dispute. Parties are negotiating to settle the dispute. We issue notice to opposite party.
Opposite party number 2.
Opposite party number 2. The petitioner may move application before the court below for seeking an adjournment in view of the fact that the matter is sub judice before this court. Yes, next.
45.
May I please, your lordship? My lord, the petitioner has come before this honorable court to quashing the order of cognizance dated 15 to 2023 and to quash the criminal proceeding, my lord. For the alleged commission of offense under section 420, 294 and 506.
Yes, the grounds, you tell me the what.
Yes, my lord. The allegation is that, my lord, petitioners had taken 16 lakhs of rupees for selling their land to the informant, my lord, in advance. Total amount to be paid 71 lakhs, my lord. And allegation is that, my lord, now the petitioners neither returning the money, and that's why they have lost this FIR against the petitioners, my lord. But the fact is that, my lord, the petitioners has already returned their money, my lord. Return their money.
16 lakhs you return.
Yes, my lord. 16 lakhs we have already returned. Cash 10 lakhs and in check 6 lakhs, my lord. That is at annexure for you also may kindly see. And it's purely a civil matter, my lord. Breach of contract between them, my lord. And criminal case is not attracted.
What about the land? Land is there in your name?
Yes, my lord. Land is our land is in the name of petitioners, my lord. Informant came to buy the land, and
why don't you settle?
My lord,
settle the matter.
We have already returned their money, my lord. They do not want to purchase. They did not want to buy the land.
Any suit filed specific?
No, my lord. No, my lord. Nothing. And
there is a written agreement.
Yes, my lord. Written agreement is there, and
show me written agreement.
Written agreement that has not been executed, my lord. That is only
show
written.
me that written agreement, sir.
Written agreement is not there, my lord.
Not there means you said that is there. You have not filed. That's the different story.
No, my lord. It's a clear case. Jiman, you also may kindly see annexure 4, my lord. Annexure 4, you also may kindly see. We have already returned their money, my lord.
Issue notice.
Annexure 4, my lord.
Issue notice.
And similar Similar cases, my lord, this honorable court has quashed the NBW and sorry, quashed the border
Now,
of cognizance, my lord.
NBW is issued again.
No, no, my lord.
I'm issuing notice.
I have one judgment, Lord, so may kindly see.
I'm issuing notice and let him come.
Yes, yes, my
We'll
lord.
settle the
Yes, my lord. I have filed IA for.
And also the petitioner submits that he would move appropriate application before the court seeking adjournment. Adjournment on the ground that the matter is pending before the court, and he is making all endeavors to settle the dispute with the petitioner. Yes.
46.
And this application to challenge the order dated.
The petitioner is accused in the fire also. The allegation against the petitioner that he has promised to sell the piece of land and take in advance of rupees 16 lakhs. And as per the petitioner, he has returned the entire amount. Still, the opposite party is insisting on the, and still the opposite party is prosecuting the petitioner on the ground that the money has not been paid to. Yes.
Yes. 46. Yes. File this application to challenge the order dated 29/1/2024, rejecting the prayer of the petitioner, my lord. The petitioner filed the application before the London court below under section 65B of Indian Evidence Act to adduce the evidence from the electronic media, my lord.
What is this order?
Page 7, my lord.
Order dated 29/1/2024.
What is this order? By which
They have filed an application 65B of Indian Evidence Act, praying to giving a certificate for giving adduced evidence, the electronic documents.
where is the application? Nothing. You don't find
It's a
anything.
file government.
You
Say, rejection
can't
order.
make head and tail of anything of this.
Page 9, I have filed the application.
Where is that?
Page 9, yes.
Page
Page
9.
9. Yes.
Page 9.
Let's got it. Page 9. 65B of Indian Evidence.
Yes.
In the
Page
court of
9.
JMC Kontavanji, CMC number 56 of 2022.
Oh, that's handwriting.
Yes, 100. Yes, yes.
What have you said?
Yes. Petitioner filed this application basing on the record alleging which material torture of the fact and the phone calls recording are made by the
Para 3. Para 3
That certain phone calls.
recordings are made by the respondent during the petitioner's conversation with your parents, which
With
the
the
respondent
respondents,
wants to adduce as evidence before the honorable court. Mane say while she was talking with your parents, the petitioner was recording the her
And he
conversation.
wants to lead
And-
it as a defense evidence.
Yes, that recording she wants. Petitioner wants to produce adduce in evidence.
Which is declared.
Yes, that is rightly declared.
How? Why?
You'll also may kindly see somebody's personal talking.
Yeah.
All the
That is the section 20, article 21 violates.
No, what does it say?
Yes, you'll also may kindly see.
21.
Counsel for the petitioner has submitted that this petition is misconceived and incorrect. Further, he has submitted that this call recording made by the respondent was without the consent and knowledge of the petitioner. Further, it is a violation of right to privacy under Article 21 of Indian Constitution. He has also submitted that these phone call recordings made by the respondent during the petitioner's conversation without obtaining the consent of the petitioner itself amount to torture and cruelty by the respondent against the petitioner. So he prays to reject this petition for the end of justice. He has also filed a memo of citations. Then you will next page, Your Worship. The High Court of Chhattisgarh support of his submission. After hearing both the parties, this court is opinion that the PWDV Act is a social beneficial legislation having an object to provide for more effective protection of right of women guaranteed under the Constitution.
What are the offenses you are trying?
DV Act.
DV Act, my lord.
DV Act, my lord. Domestic Violence Act.
Domestic Violence Act.
Domestic Violence Act. It's a.
May I please? Here, the petitioner of your lordship is facing trial in a case under 6363, 376-2 and and 506 and 6 of the POCSO Act.
Yes.
And
Yes, injury report. Yes. Where is that injury report?
3 injuries.
Give me.
ଆଉ ନାହିଁ କି? କଣ ଆପଣ ଗୋଟେ ବାର କାଉନସିଲ ଗୋଟାଏ କାଗଜ ସଟେଜ
Sometimes some heavy cost has to be imposed on him. The way he that.
yes yes member of the bar council ଆଣିଛନ୍ତି ଗୋଟେ ପେପର
What did it say?
Investigation going on.
हिंदी में बात करें
Simple or what?
सर ओपिनियन टा कोड काई बना पड़े
Opinion କିଛି ଦେଖେଇଛନ୍ତି କିନ୍ତୁ
Required
required
କଣ କରୁଛନ୍ତି
required
Nothing.
କିଛି କିଛି ତତେ ଦେଖା ଯାଉନି ଦେଖିଲି
No indication whether it is
इंडिकेशन କିଛି ନାହିଁ
ନା
whether it is simple or grievous
simple grievous ଲେଖା ହେଇଛି କୋଉଠି?
ये ब्लड
required बोले ये देखो it could be required बोले
the asset repaired wound recent asset repaired wound injury is of recent asset repaired wound repaired wound
Repaired wound.
yes
But simple grievous what?
କିଛି ତା ଉପରେ କିଛି ନାହିଁ there are 3 injuries 1 2 3
Right down. The instance of opposing. How many accused are there here? You want
3 petitioner 1 petitioner 1
How many accused?
3 petitioner 1 petitioner
repaired wound
accused 3
Then you
only
are
for 1 before your lordship 1 petitioner
where are the
One
other accused? You the
so for the pedal petitioner your lordship was the for the pedal petitioner concern
in the same problem.
आप सबके लिए कंप्रोमाइज करते हैं या इससे इसके लिए
बाकी
और जो बाकी नहीं
वो बाकी
नहीं कंप्रोमाइज करेंगे
मतलब 3 ही नहीं है
ना 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 ये नहीं था तुम डिसाइड नहीं करोगे ये बताओ कि तुम कंप्रोमाइज किसके साथ कर रहे हो और जो दोनों बच गए उनके साथ नहीं करोगे
ये तो प्रॉब्लम है ये तो प्रॉब्लम
you cannot choose absolutely not right cannot choose ମୁଁ ଆକୁ ଆକ୍ୟୁଜ କରିବି ଆକୁ ଆକ୍ୟୁଜ କରିବିନି
यार allegation
July pen.
यार allegation होची
That can't be done.
ହବନି
entry protection
3 injuries, serious injury. He is compromising with one.
नहीं
the
नहीं
other 2%.
ये spot भी नथला ये
Whatever on merit you argue, that's a different story.
मैं partially कर परिए लट्स काइंडली
ऐसे नहीं परियो
ठीक है आपण देखो ये लट्स काइंडली
See, the fact is
ये लट्स काइंडली
injury report indicates there are 3 injury. It doesn't indicate whether it is simple injury or grievous injury. You are settling with one.
लट्स काइंडली
And it will directly impact with in the
suppose the trial established that other 2 have not assaulted and this person assaulted if it is established supposing accepted
facts are
the problem हो सेटा होची कथा अच्छा ठीक अछि एटा गोटे अर्जन थाउ से डिसीजन टा देखिबा कोन अछि
नहीं नहीं
facts may be different.
नहीं ये
वो circumstances को देखियो बरन
ये नहीं इंजोर
प्रॉपर्टी डिस्प्यूट अरे एटा पण गोटे
These are 468,
468
These are
one thing that you will see interim protection
I simply adjourn it.
no interim protection interim no persecution no for
This is not bail court. You don't do that.
say
Please. Next.
say only no persecution
48.
कोर्सिटा हला चलिबो
No course of action. Some other court, not this court.
ना before vacation था
See, this is a very dangerous way of negotiating.
नहीं इंजुरी स्टेज उन अछि सेम डे डिस्चार्ज है सेम डे
Why
डिस्चार्ज
he is not settling with the other 2 accused person? There are 3 injuries.
allegation अछि से कहू ये ऑन द स्पॉट भी नथला
He will not decide. Why has he given the FIR then?
निजे कहछि ना
Why has he implicated him? Today he has taken some money and saying that he was not. And he will be the informant, he will be the injured, he will be the judge.
मैं प्रेयर वन थिंग वाला
तुम्हें समाधान करना है
बिफोर वेकेशन के था वो मोटे आउट सैटिस्फाइड बिफोर वेकेशन वो डेट
पूरी 21 तारीख 20 that first I can 20
अच्छा बात है।
ऐसा थोड़ी होता है
नहीं
कोई
करेगा उसके साथ इसके साथ
he will
करेगा।
implicate anyone and thereafter take money and say that I'll pass I will not press the case against him.
ये बेफिक्र ठीक है।
Yes, 20
But nice.
ऐसे मत करो। Yes.
Let's say present petitioners have filed this petition for quashing of this proceeding. Let's say petitioner and the informed both are laborers. Due to civil dispute, this case has been posted and this matter has been settled.
Where are they?
Let's say fixed date they have been present.
এই কেসের কোন হয়েছে আদরে there are two injured persons. One is Dhaneshwar Nath, one is Rakesh Nath. They have sustained multiple injuries and grievous, and 5 accused persons total in the charge sheet.
All the
three are the petitioner before your lordship.
Same problem.
And anticipatory bail twice rejected, no certificate given. And now they have filed for compromise.
They have
How do you say it is a civil dispute 307?
Let's
You have beaten the person.
Let's see.
Grievous injuries are there. You say it's civil dispute.
Let's say
multiple injuries.
Let's say accused in this case all the family members.
Then you have a right to.
No, my lord. No.
Injuries are grievous in nature. There are 5 accused. 3 accused are now have filed this petition for quashing. What about the other 2?
Let's say charge sheet has been filed against 3 persons.
3, okay. Injuries are serious.
Let's 2 grievous and
what is the relationship between this
neighbors? Neighbor.
Family, you said family. Yuvraj Nath.
Let's say accused are
Warrior Nath. Babul Nath. Sumitra Nath.
चार्ज शीट रो लास्ट पेज टा लॉट्स में काइंड से चार्ज शीट रो लास्ट पेज ये पेज मार्किंग करना दे
Yes.
बट चार्ज शीट रो लास्ट पेज टा ठीक during course of investigation the second para start the words during course of investigation.
Yes.
Let's got it.
Yes.
Yes, after 4 lines.
Yes.
Describe have been given injury requisition was issued in favor of injured Dhaneshwar Nath and Rakesh Nath, and MO opine has been obtained. The MO opine that the injury reflected on the body of Dhaneshwar Nath. You also got it.
Deep. Inside stone. 14 centimeters.
How many injuries are you lost? These are the situations.
Grievous in nature.
Yes, all grievous.
All cutting weapon.
And both injured has not made as parties in this proceeding.
Let's say informant made as party and all the members are present before the civil court.
Who are the injured?
Let's see.
Dhaneshwar Nath and Rakesh Nath.
Let's see second application of Dhaneshwar Nath. Item 50. Let's see.
Whether we should do it or not. Grievous injury.
14 centimeters. एथर पार्टी कर दो, एथर भी पार्टी करो.
I party कर.
Mail.
Party कर. Then comes out petitioner seeks permission from seeks leave of this court to implead the injured in the present case, and let him do so within a week. Leads the matter. Once you examine, injuries are very, very serious in the head.
No, my hand.
Head, let's see. Stop.
Let's see, kindly fix it date.
Date 14 centimeter into 3 centimeter into 2.5.
Well,
we don't know what is the condition of this injured. See, okay. Date
57.
Yeah.
50 at same.
Same.
50.
Same. तादरे दी जन accused आदे 3 जन एमती अछन. तादरे जने अछि आदे 2 जन अछन.
Immediately open it. Only 20. Yes.
52. Let's be 20 maybe at 20. Last working day.
Yes, 52.
Of the criminal proceeding on the ground that they married and blessed with a child. On the
This to the child.
yes, ma'am. That birth certificate of the child I have annexed on annexed to page 15. They are present, ma'am. In fact, as per the Aadhaar card, the age of the victim,
Who is the informant?
informant is the victim herself.
Victim herself.
Yes, ma'am.
She was minor at that time.
No, minor, I am supplying the copy of the Aadhaar.
When she was the minor, also is there.
Someone is switch appear କରିବା ପାଇଁ
ସେଥିପାଇଁ ସେ ମାନେ
ସେଟା କାଇଁ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି someone is switch କଣ
what is the ground?
କଣ ମାନେ ପ୍ରୋବ୍ଲେମ କଣ
Police has vindictively lost the affair and if such a hello.
What police?
Police now vindictively FIR the lodge against 3 persons out of 31 person. The petitioner has not entangled in this matter, my lord. 3 persons. The petitioner has reached at the age of 71. Ultimately, he has not entangled in this matter, my lord.
At this stage, how will I ascertain whether you are there or you are not there? This is only the cognizance stage. You have to participate and prove all these things before.
ଖାଲି FIR ଟା ବି annexure କରିଛନ୍ତି ଆଉ
You have filed only the FIR.
Order ଅଛି
ସେଇ ଯେ ସେ cognizance order ଟା FIR ଟା ଆଉ କଣ
This is in fact a premature petition.
ସମନ ଟା ଇସ୍ୟୁ ହେଇଛି appear କରିବେ 2017
ଆପଣ withdraw କରିକି I give liberty you argue all these things points before the court will.
ଆଉ କଣ କହୁନାହାନ୍ତି କିଛି କହୁନାହାନ୍ତି
What is your case you try to
considering
you may have a case but you have to tell me what is the case.
above the cognizance taken against the petitioner by the order at Lord James U. Chandikar and proceeding in JR case number 2 prayer 2000 arising out of Balsam case number 3 and my gas pass any notice issue.
ସେମାନେ ସମସ୍ତେ ବେଲରେ ଆକ୍ଚୁଆଲି ଅଛନ୍ତି ସମନ ହେଇଛି appear କରିବା ପାଇଁ ଆଉ ଡେଟ୍ ଫିକ୍ସ ହେଇଛି 25/6/2024 appear କରିବେ ଆପଣ କଣ ଆଧରେ ପ୍ରୋବ୍ଲେମ କିଛି ନାହିଁ ଆପଣଙ୍କର କିଛି ପ୍ରୋବ୍ଲେମ ନାହିଁ ଆଧରେ
You want to say something.
କିଛି
What exactly you want to tell?
Exactly, I want to quash the order.
It's all right, you want quashing up for the cognizance order, but you need to have some ground. What are the grounds? Do you have any ground? Right. The petitioner seeks to withdraw this petition to raise all the points in the court below. It's the appropriate stage of the trial. With this liberty, the petition is disposed. Yes. 54.
May I please, Mr.
Yes, sir.
My lord, in this case, the FIR was lodged in 1991.
Yes.
Offense under section.
You are challenging what?
I am challenging
Cognizance
the
order.
cognizance order.
It was taken in 91.
Yes, ma'am.
Today you are coming and challenging it.
Well, I have no knowledge about the case because FIR was registered on three unknown persons to enter the petitioner house and
Let's see what is the stage of the trial now.
I know only informant has already died and all the bail all accused persons are died. Only
ନାଇଁ ନାଇଁ ଆଦେ ସବୁ ଗୁଡା କୁହନ୍ତୁନି କିଛି ପଢି ନାହାନ୍ତି ଫାଇଲ କରିଛନ୍ତି ଆଦେରେ ଗୋଟେ ଆକ୍ୟୁଜ୍ଡ ମରି ଯାଇଛି ବୋଲି ତାର ରିପୋର୍ଟ ଆସିଲା ସେଇ ରିପୋର୍ଟ ପାଇଁ କେସ୍ ଆର୍ଜନ ହେଲା କାର୍ଯ୍ୟନ ହେଇସାରିଲା ପରେ ରିପୋର୍ଟ ଆସିଲା ସବସିକ୍ୱେଣ୍ଟଲି ଦି one of the accused he has died thereafter this accused and another accused they are absconding but somebody has stated that this petitioner has died only because of that learned court directed the police to cause production whether he has died give a report whether he has died or alive.
You have given a report that they are alive.
They are alive. Okay. Now he is absconding and warrant is pending. Warrant is issued
when was the warrant issued?
2/2/2024. Fresh warrant issued. 2/2/2024.
Where is that order?
Lordship kindly turn to page 33. 33 order dated 2/2/2024. Last.
33. Okay.
Yes.
1 minute.
Last para.
1 minute. 33.
The case docket is
Yes.
The case record is put up today on receipt of live status.
Which proceeding?
My lord,
Dated?
dated 2/2/2024. The case record is put up today on receipt of live status report of accused Sudhir, the petitioner, Sudhir Jena. So on perusal of same, it is found that the accused is alive and residing at the house.
My lord, I am not Sudhir Jena. I am Sudhir alias Budha Parida. Sudhir Jena is another accused person.
I will just quash the NBW, allow you to appear before court and tell all these things.
केवल तादर लेखा है गोटे जे जदि आसी अपियर करिवे ताल भीनामा एक्सेप्टेड हो भीनामा ऑन बिहाफ ऑफ द सुधीर परिडा advocate file a भीनामा court observe that unless the accused appear भीनामा cannot be accepted.
Write down. You let him go and appear and
yes
sort
down
it out.
done.
No course of action. I have had.
I'm saying it, sir. Right off. By order dated 2/2/2024, the court of JMFC 1 Bhubaneswar has issued the NBW against the submit that his client would appear on or before
June
कौन तू
June 30.
June 30, okay. On or before 30th June also, and move appropriate application under law. Subject to petitioner appearing before the court on or before 30th of June 2014 and moving appropriate application seeking a remedy available to him under law. The NBW issued against the petitioner by order dated 22/2/24 shall remain shall kept in
sir seita in respect of Sudhir Jena not Sudhir Parida na केवल direction है से appear करिया ପାଇଁ only for appearance case is posted for appearance.
He has written Sudhir
सेटा दीटा सुधीर अछंती सर दुई जण सुधीर अछंती
जण accused
जण सुधीर जेना
I can't do anything because the whoever is the petitioner he'll get the benefit. I can't presume that somebody else is there.
No, the petitioner is Sudhir Parida.
Sir, petitioner is Sudhir Parida.
The last
Another
order is
accused
I am passing this order for you only.
Yes.
Sudhir Parida only.
Sir, my against NBW.
NBW ताको against हेइन.
अरे का against?
ये सुधीर
जेना against रही.
सुधीर Parida खाली someone हिची
someone है police arrest करी.
That is your lordship में kindly
no course of action.
It's all right. Okay.
Order dated 6/2/2024.
6/2.
Yes.
By order dated
6/2/2024.
By order dated 6/2/2024.
Yes.
Summons has been issued to the petitioner. There are two issues in the present case. The present petitioner is named Sudhir
Parida.
alias
Sudhir
Budha Parida.
Budha
Parida. Whereas the co-accused name is Sudhir Jena. Insofar as the co-accused Sudhir Jena is concerned, NBW against him has been issued by order dated 2/2/2024.
Yes.
Insofar as the present petitioner is concerned, the court below has issued summon on
6/2/2024.
6/2/2024. After the court submit that we will appear before the court on or before also and securely subject to petitioner also no course.
Obliged.
Subject to instead of NBW execution of NBW no course of action subject to the petitioner appearing before the court on or before 30th June and availing the remedy under law. You appear.
Yes.
I am only giving this indulgence because this case is from 1991.
Yes.
That is why I am giving. I have no course of action till 30th of June. Go and appear and seek your remedy.
Obliged.
Okay.
Obliged.
Okay. Hello.
56.
Yes. Yes, 56.
55 to advance.
55 after 2 p.m. compromise.
Item 55, my lord.
Yes.
Let it come at 2 p.m. I'll come personally, my lord. I mean, the parties are also.
Yes.
Grateful.
56.
Please. In this case, there was a proceeding initiated against the petitioner under 75, 80, and 81 of the Juvenile Justice Act. Subsequently, Lordship, the relevant part of the judgment is at page 33.
You are assailing what?
No, here what has happened, the petitioners were acquitted. Now, in the order, in the judgment, there was a direction that the investigating officer will hand over the rescued female child to the petitioners. There was a direction in the judgment itself. After that, also I have approached the investigating officers, but they have not acted in pursuant to the judgment. That is my claim. Here there was an adoption deed. Adoption deed when I had adopted a child.
Okay.
But there was an FIR against me that there is no adoption, and under the Juvenile Justice Act there was a proceeding initiated against me. Now
Got acquitted and
I am
direction was
acquitted.
to- Direction was to hand over the child to
Rescue.
you.
Yes.
Where
That
is
is
that direction?
page 33.
Page 33.
33.
Yes,
Okay, 33. Let us see.
second para.
Yes, 33.
Page 33, second paragraph.
That's got 33, second para. That's you got it?
Yes.
Yes.
The IO is directed to hand over the rescued female born child, namely Ananya Pradhan, to the adopted father, namely Lalit Pradhan, the petitioner, and adoptive mother, namely Sushma Pradhan from Rukmani.
May what is this? It is something is reproduced, it seems.
No,
In a
that-
single space it is written. Enter this case as a mistake of fact. For
For statistic-
statistical purpose.
No, after that, the direction is by the court itself. The direction is of the court.
IO is directed to hand over the rescued female child, namely so to the adoptive father.
Adoptive father, namely Lalit Pradhan, and adoptive mother.
I'll take instruction. I'll take instruction. I'll take instruction.
They should give it. See, the order was passed way back in 2020.
Right.
Where is that child?
If that is there,
Where is that child?
I don't know.
Where is that child?
As per my instruction, with the investigating officer.
ସେ କଣ ତାଙ୍କ ଘରେ
ମାନେ ସେ ରଖିଲେ ମାନେ ସେ custody ସେ court
ଆପଣ ଜାଣିଥିବେ ନା ସେ କୋଉଠି ରଖିଛନ୍ତି?
You must be knowing what kind of adoptive father you are. You don't know. Very
No, the proceeding ହିଁ ଥିଲା ତ ସେ
proceeding ଥିଲା, you
କୋଉଠି
must be
ଅଛନ୍ତି
knowing.
ବୋଲି କହିବେ ନା
ସେ
ଆପଣ?
କୋଉ ହୋମ ରେ ଗୋଟେ ରଖିଥିବେ ସେଟା
ମାନେ ଆପଣ ଜାଣିନାହାନ୍ତି କି ଆପଣ
You don't
ପ୍ୟାରେଣ୍ଟସ୍
keep a
ହେଇଛନ୍ତି
track
ଆପଣ
of-
ଜାଣିନାହାନ୍ତି?
ସେ
For
approach
your child.
No, ମୁଁ approach କରିଛି ମୁଁ that I have also annexed. I have
That's
approached
true.
on multiple
Do
occasions.
you have any idea where is the child?
No, that instruction.
2023 this order was made.
Still is
The child is neither here nor there.
That instruction.
Neither with the
Adopted parents?
biological parent nor with the
police.
And that's why I have requested also that
which
also
police station is this?
এটা
Rairakul, Sambalpur.
না না চারমাল
Charmal, Rairakul, Sambalpur.
I'm
Yes, yes, I'll
listing
take
it-
instruction.
No, listing it tomorrow. You call the SP and tell me. We
ନା
can't
ମୁଁ
leave it.
ଫାଷ୍ଟ ଗୋଟେ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣି ଇଏ ତ ଜାଣିନାହାନ୍ତି କଣ ହେଇଛି ଆକ୍ଚୁଆଲି ଫ୍ୟାକ୍ଟ ମୁଁ ଆଗେ ଦେଖେ କଣ ହେଇଛି
But
ଗୋଟେ
he might have
instruction
committed mistake, but we can't.
ମଣ୍ଡେରେ ରଖନ୍ତୁ ମୁଁ ନେଇ
No, this tomorrow, last item.
Tomorrow,
You
yes.
speak to the SP.
yes yes I'll do
Where is the child?
yes
You speak to the SP and tell me.
yes yes
Little bit
tomorrow
more.
aso tomorrow
Okay.
Yeah, I don't know what the poor child must
Yes,
be
yes, that's
suffering
right.
somewhere.
ସେମାନେ ପ୍ୟାରେଣ୍ଟସ୍ ହେଇକି ବି ସେମାନେ
What prevented you to come to the court earlier?
I have approached that I have also annexed 2. I have approached on multiple occasions.
You are dealing as if it is small.
I'm sorry.
Somebody is right and poor
and
child.
another
We should have
482
approached.
application was filed before this honorable court no certificate was given
You are dealing as a casual litigation.
CRLMC
Will
number
not give-
2510 of 2023
What is this?
what is that I don't know but
So
that has not
that
been
was
given
at the stage
certificate
of trial. That earlier CRLMC was to recall a witness at the stage of trial. Now that is over. That is not connected.
Where is that?
no certificate has been given
That is still pending.
No. That is
ନା
disposed
କଣ
of.
ହେଇଛି କଣ ସେ କହିବେ
2501.
See, these are the cases you shouldn't deal like a common litigation.
Lord.
I'll
Get
take
the
yes.
instruction tomorrow
Yes, yes.
from SP.
May,
Tomorrow, this.
Oh, please.
may pardon.
Yes.
May, item 47, my lord. That recall of that the victim, your lordship was not inclined. Liberty be granted to file a properly constituted that observation that will serve the purpose.
Liberty is there, then he's opening it again
No.
another
Pandora's box.
slot gate.
Only I will. In the meantime, victim has been married 23 years.
There is
Raised
a
with
bar
2 children. No, I do.
That 33(5) is bar. I can't allow that against bar. I can't allow you give the liberty. If there is a bar, how can I give a liberty?
No, see, once he is at a majority,
Therefore,
section 94 of the JJ Act will not stand on the way.
Therefore, I have observed that it will not preclude you to lead further evidence. That I have observed.
Item 91, my lord, matter has been settled, my lord. Both the parties are present, my lord. 2 o'clock, my lord. My lord.
Item 57. The next item, very next item. This is appeal is to be admitted only and 2 years conviction. 57, the next item. The 2 years.
Sentence is 2 years.
2 years.
Mr. Das, no? Mr. Das.
Vigilance matter.
Vigilance case.
Of his mother, my lord, today.
I know his mother, but it formal.
Sanjay Das.
Sanjay Das, Mr. Sanjay Das, there is a bill pending.
Yeah, but presence is just 2 years conviction.
2 years of conviction.
Conviction.
Press.
Admit and
58 also. But 58 also same prayer.
Prayer. One prayer, my lord. On 11th, my lord, that 1 month of interim bail expires. Can I pray for a certified copy in course of bail? Your lordship.
He'll give it.
Grateful.
My lord, I may pardon. 58 grace admission. Sentence 4 years. He is in custody. During trial, he was on bail.
Undergone how much?
My lord,
Undergone how much?
undergone 1 month 15 days.
Custody 1 month.
4 year, man, 4 year conviction. 4 year conviction.
Up till 7 years, I am giving.
No, 4 years. 4 years conviction. 4 years conviction. Why not grace it?
He says some problem, then must understand. So what do you want?
So let it come.
Day after tomorrow holiday. Friday holiday. Monday.
The problem is the council, there is a bill pending in the
Man, I know, my lord. His mother's.
to do and he has all right.
My lord, if it is not fresh admission, I would not have. This is my lord's area. I leave it to my lord.
Keep it.
My lord, I pray one thing.
Heaven is not going to fall.
My lord.
Suppose I will reject your application. What will happen?
No,
If you want your application to be allowed, Monday.
No, my lord, I pray one thing, my lord. The appellant in cost.
So much. There is a bereavement adjourned to June.
No,
you must recommend it to your brother friends. What is this?
I concede with my lord.
His mother died and you want insisting something.
No, he's in custody.
Adjourn it to May, June.
My lord, he's in custody.
No, I will not. You should be compassionate to your friends. Somebody's mother died and you are insisting.
Tomorrow.
No.
Tal Monday.
Nothing to it.
Monday.
Let him suffer.
Monday.
What is this? This attitude I don't like. His mother died and you insisting.
Monday.
If I may pardon,
Monday, my lord.
item number 12, I was missed out. The non-appearance may be ignored, your lordship. Item number 12.
With due apology, Monday, my lord.
You must understand.
Monday.
Mother died and you are necessary. Sasata witness. You have not cross-examined anyone.
And the court will mention that
all these 7 witnesses are examined in different dates.
Yes, my lord. Different date, but I have not cross-examined any of the witnesses.
Why?
Because, my lord, due to some sort of problem that not counsel appearing for the petition.
council present
present थी लेकिन उससे ऐसी कॉल ना I can reject total सब कुछ लिखा है.
Question 1 question 2 question like that.
हाँ sir. Clearly details किसी पहुँचे नहीं.
The first witness was examined on 12th April 23.
Again. Second, my lord says same day, 12th same day. And my lord says same day, 3 same day. And fourth, my lord, that on 4th day, 4th day July. And another, my lord, 24th July. My lord, that another, my lord, 24th. Dita date रही जन 12 out 24th. Dita date रहे. So dita date कॉल है वो समझता हूँ क्या without any fail, and I am also undertaken to deposit some amount the visiting costs of the witnesses, my lord. I am ready, my lord.
What is the offense?
306 and 354, 354B, and by the trial court, if it is applicable,
it will be taken into consideration. No, so कौन नहीं कौन पचारे तो सीमा रही नहीं. That is to be.
Court city court city ଅଛନ୍ତି ଦେଖିବା ଆଜ୍ଞା
ତ ଯିବେନି
ନା court city
ତାହେଲେ ଆପଣ
ଅଛନ୍ତି
ଏମିତି କାଇଁ କରୁଛନ୍ତି?
ନା court city ଅଛନ୍ତି ଦେଖିବା ପାଇଁ ସବୁ ଜିନିଷ
କୁଆଡେ କୁଆଡେ ପଳେଇବ?
ନା court ଅଛନ୍ତି court ଯୋଉଟା invalid question court କାହିଁକି ତାକୁ ଗ୍ରହଣ କରିବେ?
It also directed to supply the supply in advance the proposed questions to be put to the witnesses. The trial court shall consider the relevancy of this question
Exactly.
before subjecting the witnesses to process.
Exactly.
Yes.
Obliged.
Yes. Yes, next.
The item 55 is a sensitive matter. The live streaming can be paused for a moment.
Direction
Yes.
to appear the injury person. The injury person today
Lieutenant filed.
Yes.
yes.
ಈಗ ಏನ್ ನೋಡಿದ್ರಿ ನಾನು ಪಾಟಿ
207.
207.
Yes. Injury simple.
Injury simple.
ನಾವು ಪಾಟಿ ಕೊಡ್ಸಲ್ಲ ಬರ
Where is
हाँ
injury
party
report?
कर देती. I have already made party them.
Injury report.
They also have to come to the court.
ಸಿಂಪಲ್ ಏನ್ ಹಚ್ಚದ
Simple in nature.
नहीं injured ना था कोई तो option.
हाँ अच्छा.
ಇಂಜುರ್ಡ್ ಅಲ್ಲ ಎಸ್ ಕೆ ಸಲ್ಮಾನ್
हाँ तो देखो.
ಎಸ್ ಕೆ ಸಲ್ಮಾನ್ ಕ್ಲಾಸ್
आधा कर देती.
ಅವರೆಲ್ಲ ಆಜಾದ್ ಅಲ್ಲಿ ಅವರ ಆಜಾದ್ ಅಲ್ಲಿ
अच्छा वाली के.
ಆಜಾದ್ ಆಜಾದ್
गलत बात है.
Who is appearing for them?
ಹಂಗ ಹೋಗ್ಲಿಕ್ಕೆ ಇಂಜುರ್ಡ್
Opposite party number 2, repair was opposite party number 3 and 4 are injured. The injured is stated to be injured are stated to be minor in nature, simple in nature.
Simple in nature.
Injured sustained by the opposite party number 2 and 3 are taken to be the indication against the
Environment number 5.
is that P3 para 2. The prisoners in the opposite party are present in the court.
But so far the injured number 1 is concerned, my lord. Sustained simple injury. SK Salman. And so far the another injured, my lord, Azhar Ali, my lord, he has sustained injuries, my lord. He referred to the capital hospital for an opinion reserve. Does not count.
मैंने बहुत he is not admitted in the
ये लिखा है जितना
सेटबल थिला से यार.
सेटबल से आता कंडीशन इंजुरी से असला से
आपकी तरह करो.
Joint affidavit dated. In the affidavit says it really stated that they have settled the dispute. Their neighbors are what?
पड़ोसी
पड़ोसी पड़ोसी गोटी family.
They are the petitioner and opposite parties are neighbors and to maintain peace and tranquility in the area. They have settled their dispute on the intervention of legal defendants. Therefore, the opposite parties are not interested to prosecute the petitioner. Mr. Lagla, at least from the state minister, is the party that addressing the dispute. And what is the stage of the trial?
Trial started like
No, no, my lord.
Trial is
Not
not
counts.
Begin. And begin. All the parties have filed the adjourned deputy for the court, and the injury sustained by the opposite parties are therefore there is no impediment in pursuing the relying upon guarantee law. And how much cost?
बार
How much cost you will pay? How many for you?
इंजुर्ड में बार 3
तीन जन अछंती माने इंजुर्ड अछंती
दी जन इंजुर्ड दी जन
ये उनके 2 जन जने इन्फॉर्मेट है
44,000. 2000, subject to the petitioner paying 2000 each to opposite party number 3 and 4.
Right.
4, the so cost.
Receipt of the vendor.
4,000.
91 91, yes. 91.
Both. The matter has been settled, my lord. Both the parties are.
What is the offense?
498, 323, 294, 506, my lord. Ekati Roshan.
Residing together, madam. After the
Anyway.
That means it's about opposite party number 2.
BSUC ଆସିବ BSUC
BSUC decision.
decision ଆସିବ
କାହିଁ ସେମାନେ କାହିଁ
ଆସେ
ସାଙ୍ଗ ରହୁଛ
FIR ରେ କଣ?
498.
498, 323, 294, 506.
FIR number 215 to reissue the allegation against the petitioner. Is that page 3 paragraph.
If he says so, I will quit practice. I will prove that it's on record.
All right, don't.
No, he cannot say no. He cannot say I am lying. He is a liar.
No, no,
So
but-
if he
no.
starts this,
1 minute.
again some misleading statement will be made. That is the reason I am objecting to this.
If a lordship permits, my lords.
See, bar needs you. Don't leave the practice.
No. Milords, I need good reasons for that. Certainly not for somebody's lie. I can prove it.
I'm not on that. Oh, 1 minute. Before anybody submits, lordship turn to page 11 of that brief plots.
Brief notes.
The page 11 of this brief.
Hey, what is this case? Let me understand.
Yeah, Lord,
One minute.
Understand. In my case,
I'm not the merit, my lords. I'm not.
merits.
What I suggest, two cases are
Well,
names
for
of
17 years they have been languishing. They would have been engineers in chief. Because of the latches of the vigilance department, the matter has been kept pending for 17 years against interim bills paid, which would have been adjusted towards final bill. And 17 years, no charges, nothing, my lord. They just kept, the cases are kept pending and they have, their promotion has all been withheld. Well, is this how the vigilance department is supposed to behave? My lord?
May I submit, my lords?
The promotion can't be withheld because I gave a judgment.
My lords, they have, the department doesn't listen to your vigilance cases pending against you.
But my judgment will cover you.
True, my lords. But let me explain to your lordships what has happened. 17 years back, my lords. My lords, we had certain works were being executed. The clauses of the agreement contemplated that all the bills were to be paid as advance, and payments were to be made as advance payments, and they were to be calculated when the final payment was to be made. Your lordships may kindly see the clause at running page 66. This is sub-item.
Sub-item.
Criminal revision 199 of 23.
The second item. First is mine. The second item.
What are you challenging? You are challenging.
My lords, I am challenging firstly, no cases made out against us as per the terms of the contract. Secondly is delay, my lords. I am referring to Vakil Singh as well as a judgment of this honorable court, wherein again, my lords, for a delay of 13 years by the vigilance department, this honorable court was pleased to quash the entire proceedings. They said, what are you doing for all these 13 years? You can't even frame charges. For 17 years, you can't frame charges and suddenly you come up, out of the 9 accused persons, 4 are already dead.
In this case?
Yes, my lords. In this case. My lords, the clause stipulates.
Must be waiting for another 5 to die.
They are waiting.
Lord, if lordship permits.
And the case, my lords, before completion of the work and before the payment has been made, the contractor died, the bills are not being paid because they have seized the documents. The work could not be completed, nor bill could be paid. And at that stage, they initiated this proceeding on the midst of everything.
I got an overall idea.
Just before
What he says, my lords, I am telling that. We moved this under the court earlier against the order of charge, milords, on the ground that without supplying the police papers, they are going to frame charge. Your lordship, not on merit, they admitted that during pendency before this court, supplied the papers. Now this court observed, now the papers have been supplied, you go there, move. We moved.
The court had stayed the proceeding.
No. We simply said that without supplying the police papers, charge is being framed. So court remitted
That
the
is
matter.
neither here nor there.
Yes, so it's not on merit. That much.
That's what you wanted.
No, one minute. Lordship, turn to page 11. What I mean,
11 in the first item?
First item, page 11, my lords.
Okay.
My lord, I am not of the merit on their cases, my lord.
Yes.
The giving statements is all right. My lord. They are the
It's all right,
evidence.
you tell me.
Lordship, turn to page 11, my lords. My lord, Page 11, 1.
Yes, yes.
Page 11, Lordship can say out of the 9 accused persons, my lord, the first 1 to 5, my lords. The present case, the first case is at serial number 5, my lords. Sudhanshu Mon Mahapatra, item number 1. The next item appended to this one is item number 3, Prakash Kumar Ball. Apart from these two, my lord, another 2 revisions. Item number 1, Sambhuji Acharya, he filed criminal revision number 282 of 2023. Copy has given to me. And second, the Santosh Kumar Samol criminal revision 172 of 2023. What I suggest, my lord, let these 2 matters be tagged to this one. Tomorrow will be taken up. I've got the materials to show that how there are no materials to proceed. How is a groundless case? I will satisfy.
How will you explain 17 years delay?
Lord, what I suggest, Lord, on that, I'm not on that. Lord. These 2 cases,
Like
Lord,
they are on that. That's the problem.
I'm satisfied, Lord. I'll satisfy.
He's relying upon a judgment where 13 years delay, this court is quashed. You have to explain 17 years delay.
I'll try to. I'll try to satisfy lordship. But what I suggest, Lord, so 4 revision matter against 1 input orders. Why not the 2 matters may be taken up along this tomorrow? That's
that
all.
will do. That's not.
That was my entire endeavor to apprise your lordship, lords. I'm giving the 2.
prima facie satisfy me. How will you explain 17 years delay?
That exactly. If I say something, they would say it's wrong. I'm satisfied.
We have opened our mouth.
1 minute. 1. But what I suggest, my lord, this matter be taken out tomorrow, my lords, along with these 2 revision matters. I'll satisfy your lordship, my lords. What about their matters?
14 crore. 14.
Criminal revision 282.
All the 414.
Criminal revision 282.
That no further adjournment will be given.
No, I'm ready, my lords.
17 years is.
I am ready, my lords. What is the criminal revision 282?
And
Jyotio.
And Malons, the clause
282
stipulates
2023.
that all payments made are to be treated as a
First, he has to cross the hurdle of that delay.
17 years.
If you are if you succeed there,
Yes,
then I need not go into the merits.
Yes, well, I am obliged.
If you
282
not succeed there, then
My lord, fix it at 2 p.m. or 3 p.m. or whatever time permit. End of the board, maybe 3 o'clock, 3:30, whatever. 3 o'clock.
3:30 करते, so that
Sir, 14 तारीख को फिर 15
ठीक है 15
Jyotio,
3:30.
should I repeat it?
Madam, say if an application for adjournment is made there, it will be considered. That
I
observation.
don't see 15 केवल date appearing के
Tomorrow it's there. CIM, a court जो report मागी देले, तांको statement रे, once your lordship knows, High Court calls for a report, नॉले सब ठीक ठाक थिला से High Court ना रे.
Prosecution is delaying it, and you are trying to take benefit. So don't take interim order.
No interim.
And tomorrow they will decide that, see, these people have sought this order, so that is the reason it is delayed. Wait, 15th I will decide it.
All right.
Why unnecessary getting into all?
Jyotio.
That's the reason I asked you. Have you taken
I have
interim order of stay?
I have filed a list of documents. It's on record, just for argument's
And
sake.
I think the proceeding, trial court proceeding, entire proceeding.
Entire proceeding may be.
we have a we will give a copy.
May second line.
Yes.
This honorable court will earlier page pass on orders directing the law and trial court to submit regarding status of the case. I hope it has come up. May I know what is the stage?
Might be there. Status of the case is there.
What's any witness
There is
exam?
a report.
No, charges.
Again, my lords, back to square one.
This
Charge are not in trend, witnesses examined.
This one put direct to that's
जो नुआ सीआरपी से लागू ही नहीं पढ़े पड़ो तो की संहिता पइता हिंदी मोरे तो भल नहीं सिनेमा देखि जेती सिखियोलो दिल्ली जाई सिखियोलो एटा कोन मन्ने रहिबोनी सेडा एते
There
बड़
will
बड़
be a lot of problem. There will be a lot of confusion. And after July, horrendous start.
आसीगलानी आपण लाइब्रेरी रे अछि
It's there.
Sir, full order sheet टा भी हमें फाइल करछु कोर्ट रे
172.
172
You
of
also
20
have some problem because the status report is para 5 indicates that on the petition of the accused person, the case is adjourned.
Yes, my lords.
Number of
because-
dates are given.
Yes,
My lords,
yes.
You have, if it is, the delay is attributable to you, where is the question of quashing? That is also one
no,
point.
I understand, my lords, but
Because many dates you have taken adjourned.
I don't know, my lords, because trial.
That's the status.
During pendency, we
During
say
the
that.
status report also.
And my lords, I repeat it, my lords.
Again,
This-
para 10, para 5 and para 10, it says that from 11/9/2015, on the time petition of the accused person, the case is adjourned to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. 19 days.
19?
19 dates you have taken.
My lords, there are a number of accused persons, so we don't know.
So if it is attributable, see, the question is if it is attributable to the prosecution,
Yes, sir.
you get the benefit. If it is attributable to the accused,
Yes, sir.
the entire, all the accused has to suffer. One accused will take date one day,
Yes.
another accused will take another day, then how?
No, my lords, I am explaining that during the pendency, like this revision, the other cases also filed here, they kept pending. During those periods, obviously the accused persons have taken time.
Then you can't see the
No,
idea.
no, on merit
is
also
the-
it's there.
What-
I have
the
filed
delay
it.
is attributable to the prosecution or not?
No, if it is solely attributable to the prosecution, it's a different issue. But here, my lords, if at all,
It's a
some
compulsory.
time has been taken, your lordships will calculate the time. Still then, my lords, let us say 1 year or 2 years. Then, still then 15 years are there, my lords. 17 years, no?
2015
years.
to 2017, you have sought time.
Let us say, my lords, 2015 to 2017 is 2 years. Now, my lords, still then there's a delay of 17 years. Vakil Singh on 12 years, my lords, the apex court 12 or 13 years.
2018 to 2021.
Yes, well.
As many as 50 hearing has taken place for hearing in the point of charge. Who is sought the time?
My lords,
Being
the
adjourned.
number of
Time petition filed by accused person. 50 adjourned.
my lords, if the accused persons, my lords, these persons have never.
Better
sought
you
time.
don't labor in that delay part.
Yeah, but
No, that
you-
might be.
in
labor
fact,
on
the earlier bench, my lords, directed
That might
earlier-
be one of the reasons, my lords. Still then, your lordships will deduct those 2-3 years, my lords. Still then it comes to 14 years.
Just, sir, just see the status report.
Yes,
May not help you. Just check it up. In any case, I am taking up that matter.
The order sheet is also before your lordship.
Order sheet.
And Milords, I have filed documents. They forms part of the charge sheet only for communication purpose that may be kept on record.
Yes.
But at the end, my lords, I clarify, my lords, it's not, I stated something, but the earlier bench, my lord, passed that orders directly in the trial courts to apprise this on the courts regarding the stage of the.
Only after that statement.
No, absolutely.
Anyway, I know.
Absolutely wrong.
Court pattern.
Only
Once together, your lordship takes a lenient view because somebody is engaged in some profession. Some wrong statement will affect his job. Court pardon it, did not mention it in the order sheet. And somebody is taking advantage of it. Very funny, my lords. It's all of us before us.
All right.
How can somebody lie?
We'll see on 15th, sir.
15th.
3:30.
Unless somebody is habituated to that. Nobody can do that.
We know your habit also.
What
No, we too aware of your habit also.
Just documents I will, at the time of argument, I will. It's a part of record, my lords. I have just started it.
And tag it. There. 59. 60.
No, same
No,
case.
Sub-items are, sir, is appearing. Yes.
Along with other two items.
Yes. Along with other.
Connected file.
Yes.
60.
Yes.
My lords, there is another connected item, 172 of 2023. That also, same.
172 we look at.
172 ta dekhiye.
On 72 2023, the another is 282 of 2023. I wanted these two matters to tag to this. Tomorrow it couldn't tag. Ready of 15 minutes.
Next.
May please. My lord,
Item 60 before my learned friend submits, my
just a
lord.
minute.
This case involves an important and interesting question of law, whether at the outset, if the main accused dies, my lords, whether the abettor should face a trial or not. There is a judgment of this Honorable Supreme Court, my lord, that what stage the death occurs, whether at the stage of taking cognizance, to at the stage of framing charge or the trial. What is the stage of death? I'll just place that judgment of Supreme Court, my lord. Let it come tomorrow.
My lord, charge framing is.
And that may any of
Or, I'll be in out of station.
He's arguing for you.
What is the stage of the death?
My lord,
So
tomorrow
that the
I'll be in
abettor
out of
should not
station.
face a trial.
And tomorrow, next week.
Oh no, sir. 14th is the framing of the charge date is there. Several times
I'll indicate that you will seek urgent.
Well, yes, matter is pending, he can make a time petition.
No, time
I'm just
petition.
issuing notice and giving that liberty. Issue notice to the so accept notice. Particular counselor to petitioner submit that he is move an application for the trial court for adjournment. In view of the fact that the matrix of this that application is made, so trial court
Obligation.
61.
Vigilance. May it please your lordship. Order petition under section 227
Judgment of the way.
has been
yes, sir.
Has been dismissed, has been rejected. I am challenging that one.
Which one?
Petition under section 227 CRPC seeking discharge.
Rejected.
No,
Rejected.
charge has been filed in this case.
Rejected and charged.
My lord.
Yeah,
I'm
page
challenging-
98. Page 98, charge has been
Yes.
filed.
Why don't you file revision? Not a revision. This is the revision.
It is a CRLMC has been filed. I think it is.
It's a revision.
This is the criminal. It's all right. Yes, tell me.
I am challenging that. So let them take and make a submission. Take instruction. and
May I submit, my lord? Lordship, turn to the two lines I'm placing.
I'll
Your Lordship, turn to page paragraph 8, the last portion of that judgment. Page 18, Lord. Your Lordship, turn to the last portion of the judgment.
Then I have to make a submission.
No, one line, I'm placing one line.
1-8.
80.
Para?
Para 80. The last page. The page is 815.
Yes.
815. My lord, they admittedly the case in hand, my lords, pertains to revisions directed against an order framing charge, my lords. Now, what is the scope of interference, my lord? This honorable, this court, in so-and-so case, has held that interference in an order framing charges. This case falls in that particular
So I have
category.
to make I'll make submission.
Refusing to discharge is called on in rarest of rare cases only to correct the error, a patent or jurisdiction. No amendments incorporated in this particular revisions pertains to the that error of jurisdiction, lords.
Can it be dismissed only on this
No,
submission?
raise all those points in trial.
Then I'm making some.
You take the leaf and raise all those points in trials. This is one of the suggestions I put
Then
forth.
I am making submission, whole thing I will make submission.
And the carry on.
Either he should file a written reply or I should make whole submission, not on the basis of 2 lines and then saying that it is not maintainable.
Then I'm
It will
not
be
saying
proper
maintainable.
also.
My point is that what is the scope? The scope pertains to the scope pertains to only patent of jurisdiction. There is no amendments incorporated in the entire revisions, which can be termed or termed as a patent error of jurisdiction.
All cases
So
on the
these
state-
grounds can be.
You filed response.
No, my lord, so I'll verify. In fact, my learned brother is correct. Is coming with the first time. I'll get instruction. I was suggesting that you can take the leap and raise all those points at trials, my lord. The matter
That
suffice.
would have been,
That
but
can't be-
ultimately he may do that.
Yes,
That
yes.
can't be decided
In lieu of resorting to the.
But check it up. This judgment
My lord, should be
creating problem to you.
my lord.
Judgment.
You will utilize that judgment.
My lord.
Citation लिख दो तो भाई ना दे।
कौन तुम आउट बाहर कर परिबन केते पैसा सेटू बाहर कर
He wants to utilize his judgment whole day. You are taking away that. That is the only arm he has.
No,
Attacking all the people.
Everybody knows how he does it.
No, in fact, I expect my learned friends to think about it, my lords. In lieu of you're wasting time here, you can raise all those points at trial.
No, he's very
The
fair.
scope of interference and revision jurisdiction is absolutely bleak.
Yes. Sorry? Yes, Yes.
62.
May I please? NBW was issued in 10th February
You tell me
2020.
bail date, you tell me, but rest of the thing you don't tell.
କେବେ ବେଲ୍ ଗଲେ?
Bail 29/9/2029 29/9/2009
29/2009 10/2/2003 500 500.
63.
May I please?
Yes.
Bail was granted 29/9/2022. NBW was issued 10/2/2023.
500.
64.
May I please? Bail on 6/1/2012.
Yes.
NBW ହେଲା 8/2/2012 ନାଇଁ
16/8/2023
NBW 8/2/2012 ରେ ବେଲ୍ ଯାଇଥିଲା
16/8/2023 ठीक है.
65.
Petitioner was on bail 15/4/2021 and NBW was issued 16/1/2024.
500. Yes.
66.
Bail on 26/8/2016, NBW was issued on 27/2023. 27/2023.
500.
67.
May I please? Bail was granted 30/7/2020 millets. And bail job granted 26/6/2020.
So these are 20. These are 1000.
68.
500 each, 500 each.
NBW issued 17/2/2024. Judicial revision date 23 August 2016.
23
August 2016.
Okay. NBW 17/2/2024. 500.
69 bail was granted lordship 16/10/2015 and NBW issued the 1st March 24.
500. Yes.
70.
My lord, bail granted 4/8/2020 and NBW 22/10/2021, my lord.
500.
71.
Bail was granted on 3/9/2012 and NBW issued on 28/7/2023.
700.
72.
Bail on 26/12/2017, NBW dated 21/4/2020. Petitioner bail on 26/12/2017, NBW dated 21/4/23. 23.
500.
73.
Bail on
Lordship.
28/5/2013. 28/5/2013. NBW dated 22/6/2022.
700. Yes.
74.
Bail granted on 21/1/2014. NBW issued on 2/9/2021.
500.
Lordship, I am appealing virtually.
Bail granted on 27/1/2014 and NBW issued on 2/9/2021.
63 somebody said.
Lordship. Lordship, I am appealing virtually in item 62. Lordship. It is not called up.
14th December 2022.
63 what happened?
What item?
74.
63 was not called. Lordship.
What happened? 63.
This was 63. This was
Sudhan Sekhar Das already the hell
Dispose
already allow it.
Quashing is allowed.
Oh yeah. Next.
This is another collect items.
75.
Why is he was there? Why are you not?
He associated with
Anyway.
75.
Petitioner has raised to quash the NBW order dated 14th December 2022.
Bail 27/7/2016. 14/12/2022.
500.
76.
Bail was granted on 6/7/2020 and the NBW issued on 22/6
2022. My lord, I beg to pray one thing, my lord. While filing this case, the city number has been wrongly typed, my lord. Let it correct. So I may permit to correct. You correct it. Yes.
77.
Speak loudly.
23/11/22.
Bail.
That's it.
When you got the bail?
24/11/2015, Lordship.
That is 78.
Or no BJP in this one.
High petitioners are there.
Appearance is at lower way, no.
78 Lordship, high petitioners are there. In para 5 have you given?
Which item?
78. Para 5 have you given, madam? Only wrongly, madam, BA number 65, particularly 69.
Correct it.
Yes, 5% are there, Lordships. And I given all the detailed numbers, madam.
All of them are on bail.
Yes.
Date you bail.
Para 5, madam.
Para 5 date.
Bail, warrant is, madam. We echo 24, madam.
Para 5 date. Yes. Yeah. NBW issued on. Do you echo NBW? How many of you are there?
5%, Lordship.
How much you will pay? 7 days.
Lordship.
2000 in total. Okay.
79.
My lord, bail was granted on 16/5/2018 and NBW was issued on 13/11/2019.
80.
Petitioner was on bail 8/8/2022 and NBW has been issued on dated 17/8/2023.
7. Yes.
81.
Here, my lord, para 5, my lord. All 5 persons are there. And are given, my lord.
Here also same.
Same, my lord. And order dated 19/3/24, my lord. Issue NBW.
Para 5 NBW
19/3/24. And sir 2.
If I say 2/3.
My lord.
Total. Yes.
82.
Bail was granted on 16/10/2012. NBW on 19/3/2024.
83.
53, that is relating to cancellation of bail. Cancellation of bail.
When the bail was granted?
Opposite, on being noticed, the opposite party has entered appearance. And specific case is that after being released from
What are the background of
302, allegation is under section 302. He went to the grocery shop and wanted some grocery item. On refusal, there was a quarrel and he fired the gun, by which the husband
What is the ground of grant of bail?
grounds were, my lord, your lordship may kindly turn to page 5. Page 5.
5.
Yes. 4 conditions have been given. He shall not commit criminal offense on bail.
Has he violated any condition of bail?
One of the condition he violated that after being released on bail, he
Committed another crime.
Another crime.
That would
But
be
that has been
cancellation. Go to trial court and tell.
Cancellation trial court cannot. But
What?
But
offense 302, my lord. But the violation, magistrate, my lord, religion bail under one section 76 circular 2, default bail.
Default.
Actually, my lord, come here.
And his contention before the honorable court is that the case in which he was involved subsequently, that has been ended in
Compromise.
compromise.
I have filed the judgment copy.
No, arota.
Judgment copy ta mu de
subsequent.
Yes. That has been settled.
That has been settled.
And the matter was since 2022, my lord. And in this, between the affair was lodged not by this informant.
Where is the bail order?
Bail order,
is-
my lord, that is
Annex 2, page 14.
page 2, page,
14.
Annex 2, page 14.
Bail was granted under section 167, clause 2, my lord. Because the investigation.
Can it be cancelled?
It can be cancelled, but what is the stage that is to be verified?
167(2).
Yes.
You are set in liberty.
Liberty, that is true, but after being released on bail, he should not have violated the condition. That has been done, for which we have come.
What happened, my lord? After releasing on bail, there was an affair from the side of the informant. And that was ended in compromise and accused.
Why have you compromised then?
That
He is not.
I am not the informant.
She was not.
Somebody else.
No, how? Somebody.
Somebody else.
You tell me whether 167(2) concession can be cancelled.
My lord, my submission would be, it can be cancelled if the condition while releasing on bail is violated. Because that is condition number, my lord, he involved himself.
Yes, I see that.
Yes. CRPC.
First condition.
Yes.
Shall not commit similar offense.
Yes, similar offense. While on
What was the offense subsequent?
That is. My lord, what happened?
307, 506.
341. And that.
Just get me some judgment or something. Whether.
Yes.
167.
7-2 after. Then you.
Please. Yes.
My lord, after vacation.
Yes.
Oblast.
84.
84, my lord. No response. Twice the second time.
Yes. Yes. Will you file the response? What?
Lordship, take some time to file the response.
By way of last and final opportunity, Mr. On behalf of Mr. Manas Khan, adjournment is sought. By way of last and final opportunity, one will say granted to file the response. Please line.
85. May I please, Your Lordship. Your Lordship, the petitioner challenging the order passed by Third Additional Session Judge Cuttack by Annexure 3, wherein on condition of depositing in 18 lakhs has been imposed to the petitioner while hearing the matter of the bail. The petitioner is earlier before this honorable court, at CRLM number.
Why can't you speak little louder?
Your Lordship, the petitioner is challenging the order by Annexure 3, wherein the learned court has imposed a cost of rupees 18 lakhs while entertaining a bail application.
Where is that order?
Your Lordship, that order is on the Annexure 2.
Yes.
Sorry, Your Lordship, Annexure 3, page number 18.
3.
Running page number 12. On perusal of the case records, also the investigation report is found that rupees such and such has been paid by the informant in the different accounts of the accused petitioner. The relevant para is the undertaking the effect of the petitioner agreed to return 18 lakhs to the informant.
The Learned Counsel for the petitioner submitted a memo of undertaking to effect that the petitioner agreed to return 18 lakhs. Now they are coming that that has been imposed by the court. How come?
You have said
Condition not imposed by the court. Voluntarily file a memo. He has to pay minor that amount. 20 lakhs rupees involved in this case. And a voluntary the petitioner counsel stated that they have to report it.
Your Lordship, the counsel for the petitioner has wrongly mentioned.
Wrongly memo.
18 lakhs. That should be in the shape of asset security.
Actual amount
come to my order at page 15.
Yes, Your Lordship.
Read para 2.
The petitioner is assailing the order dated 13/7/2023.
Last line. However, the learned court below has directed the petitioner to return 18 lakh rupees to
To the informant.
Or surrender of the impugn order indicates that the state condition was imposed by the court below on the statement of land counsel for the petitioner to return the amount to the informant.
To the informant.
You have made the statement, you got the bail, now you getting wiser. What is this?
Your lordship, only that can be modified that this that should be in the
Amount to involve
see,
29 lakhs.
any other term and
After
condition,
that,
any other term and condition except the case securities.
If condition would have been imposed, I could have invoked the power under the 349(2) and altered it. You
Your
have
lordship,
considered, you have made the statement.
your lordship,
It's not a condition. It is not a condition, it is a statement by you.
your lord,
I can't.
your lordship, I am relying upon a judgment that is on an
That says that onerous condition should not be put. That is general law.
Yes, lordship.
But it is not a condition. You made the statement.
Your lordship, any other term and condition except the case security.
You made the condition. Who is the informant? Informant also you have not implemented.
Not implemented.
Implead the informant, we will see. Issue notice, land counsel for the petitioner seeks leave of this court to implead the informant of the informant in the present case as opposite party number 2. Issue notice to opposite party number 2. Returnable after. Yes.
86.
You implead, bring him, persuade him, and tell him that I am not in a position to pay, so that he may be, considerate to reduce the amount. Yes. Item?
86, sir.
Yes, 86.
My lord, I am appearing for the ED.
Mr. Agarwal, everybody is scared that people.
No, petitioner will not come, my lord. Because last time also similar thing happened. They sought for a passover, then adjourned.
What is it?
Here, my lord, 205.
No. Sorry, Mr. Pondana requested because the death reference is going on. In the morning he came and requested. You should have, I told you to, you should have told him.
Code number 5 is based in death.
My lord, I was also here. He has seen me, he has not said anything to me.
That is the, you are.
Yes, yes.
Yeah,
My lord, it's a tactics going on in this matter, my lord. Last time matter was listed, passed over, then adjourned.
No, that
Yes.
case is still going on, madam.
Last time similar thing, my lord, happened.
Morning. Don't
We
you
go
have
through
Mr.
Mahapatra here, my lord.
Its clerk is moving here, my lord, since 2 o'clock. That would have intimated.
What is this?
Unfortunate, my lord.
Since morning he is waiting.
He is waiting.
We both were waiting.
I just not come to know, my lord.
This is the minimum courtesy.
His clerk is moving outside veranda, my lord.
This is very
You have
Last time also similar thing happened, my lord. I am sorry to say, because I am not.
Mr. Agarwal, I can't comment on this.
Otherwise, my lord, I could not have opposed. But this is the trick going on in this matter, my lord.
Receipt on 20th.
Receipt mentioned.
Receipt on 20th. This side.
I am for the sub item
And it made clear that no further adjournment. What is this? At least you should. The whole day is waiting for this.
From morning I am sitting, he has seen his clerk is moving here.
Yes.
They should have intimated us.
That's minimum.
In all fairness, it should be intimated.
This minimum. Anyway.
Yes. 87.
87 on behalf of Mr. Ponda, my lord. Still he is going on. On behalf of Mr. Ponda, the same matter, my lord.
Okay, he is appearing in.
Yes, my lord.
90.
No, my lord. 87 another council. Some other council, my lord. 87.
In 86, then my lord, the interim order may kindly continue, my lord.
87 some other council, my lord.
If interim order would not have been there, it would have been over by now.
87 appearing, my lord.
Interim order is only creating problem, I tell you.
The next occasion, I will be cautious.
Yes. 87.
86, my lord, kindly interim order may continue, my lord.
Interim order will continue, but on 20th, if you ask for adjournment, I will vacate it.
My lord.
I make it very clear.
My lord.
87.
May I please, your lordship? My lord,
Yes.
this is application under 482 of CRPC to quash the GR case number 1279 2022, my lord. My lord, last occasion it was adjourned as the state council has to obtain instruction. My lord.
Yes.
Case is here, my lord.
Huh?
We have obtained the case, my lord.
What is this?
And
Will
the,
it take little time?
my lord,
Hmm?
so far the petition is concerned, my lord,
No, he is asking what? Washing.
question.
Is there a problem?
Take some time, because my lord, case there is here, my lord.
Mr. Raghunath, permit that he has received the case diary. The present matter will take.
And charge sheet also submitted in this case.
Next, case diary. The charge sheet in this case has already been issued. Right? This is causing of FIR.
My lord. But in fact, charge sheet has already been submitted, my lord.
Mr. Panda, charge sheet has been filed.
Yes,
Amend
ma'am.
Don't you think that you have better option to file challenge the charge sheet?
Yes, ma'am. Will withdraw the matter and file with the charge.
Right.
Cognizance order में challenge.
Right.
Charge sheet submitted, my lord, मैंने charge sheet 14/17/2022.
Raghunath, submit that the charge sheet in the present only will submitted on
14/7/2022.
Mrs. Vanuja Panda submits that seeks to withdraw the petition with the liberty to file a liberty to avail remedy under law and to attain the charge sheet and even under law at appropriate stage. Yes.
Item 90.
Yes. 90.
90.
Somebody there? Dispose of. What is this matter? Why it is listed? Wrongly. Therefore, the seeks to withdraw this petition. Regarding the right to urge all the points before the revisional court. Dispose of. Why it is listed?
What modification?
Huh?
Modification.
What modification?
से कौन से लिखा इतना order है इतना modify para 1 of the order in place of charge has been framed against him in place of charge has been framed against him. Charge has not been framed against him. In place of charge has been framed against him. Not framed, framed against him. Prayer, my lord, page 2.
Para 1.
My lord.
Charge has been framed against him.
Not
Charge has been framed.
Not framed. Charge not framed.
No, charge has been framed. Therefore, he says that I will file the revision.
But since they have filed the IA, charge has not been framed.
Taking your June में रखो यार अर्जेंट. June last. Yes.
92.
92.
92.
Copy not साथ में.
Despite the fact that the petitioner has taken time to cure the defects pointed out by the registry, the defect has not been cured till date. None appears for the petitioner in the request of justice. I can dismiss it.
One option given if the not removed in the meantime, without referring the matter, they can dispose of.
In the event, the defects are not cured and the order dated 6/3/2024 is not complied within 1 week. The present petition shall be dismissed without reference to the court.
16.
Yeah.
16 days. 16 days.
Sorry.
Within 1
16 days.
16 days.
How sure?
No, without reference to the court.
Oh,
It will dismiss. Yes.
94.
But in view of the one set of requisites has been filed. In fact, 2 of the petitioners are minor lords. That's why being represented by OP number 1. So one set of requisites are filed and notice Could not have been.
Notice could not be served due to want of appropriate number of requisites. The counsel for the petitioner seeks time to file requisites within 1 week. Urgent. Yes.
95.
May I please, my lord? My lord, here I am challenging the order taking cognizance under Annex 2,
Yes.
order dated 26/6/2023. Here, my lord, the petitioner is a lady working as a president of the SHG group. Here, my lord, the petitioner's working period is starting from 2014 to 2018. And the total misappropriation amount,
Where is the charge sheet?
I have not filed the charge sheet, your lordship.
You are challenging cognizance order and not filing charge sheet.
Lordship, may allow me some time, I will file the certified copy of the charge sheet.
Time to file the additional document to substantiate each case. Urgent.
Lordship, I pray one thing. Petitioner is in spite of lady is suffering from
What do you want to see? Interim order.
interim order for no.
Incomplete. First of all, you file an incomplete petition.
Lordship,
Second, you are seeking
as
time
because-
to file document.
as because
Third,
of
you are
her-
asking for
As because of her illness, only I am praying for her illness, your lordship. For some.
move application there. Seeking quashing of cognizance order, you don't file complete petition. If it is so urgent, you should have filed it. What to do?
Lordship, I pray, can it be taken off next week, your lordship?
No. Next week not possible. Just see, 150 matters we are dealing here. Time is current. Why so casually petitions are being filed? On this ground only, I can dismiss it.
Lordship, may keep
I'm
it to-
giving you are a young man, so therefore I'm giving the time. Don't do that. Those things. At least I can understand. You have a exposure. You are a young man. Why are you doing that? Okay, next.
Lordship, may fix up a date, Lord.
He'll fix it. Don't worry.
Okay.
Yes.
96.
96.
Telling the order of cognizance under the NI Act at page 17, but relevant page, Lordship, can have page 41.
You are accused.
I am the accused, but in fact, I am the guarantor. But subsequently, Lordship can have only
Who has issued check? You have check.
My lord?
You issued the check.
Yes. No, I have not issued. My nephew has issued. My nephew. As a guarantor, they have taken 2 checks. The opposite part number 2 is the complainant of the
All these
case.
things are defense.
Just I am coming, my lord. Page 42 for only moment, my lord.
40?
42.
Yes.
During course of trial, my lord, admittedly 2 lakhs check has been degenerate. But
I'm not able to follow what you are
page
saying.
42, para 9. It is a fact that I have not paid money to Ashok Biswal. Ashok Biswal, the present petitioner or the accused of the case in present case. But during trial, the opposite partner 2, the complainant of the case, he said that I have not paid any money to Ashok.
These are the evidence which has come on record.
My
Trial
lord.
court will appreciate. Where is the question of watching?
For which, since case is going on, my lord, I
Let
have
it go on.
for moment,
These are the evidence came on record.
my lord, I have obtained
And
one of
the
the
trial court will appreciate,
My
or
lord,
I will inform it to
my lord, for a moment, I have obtained one order of the issue of the notice has been issued against the opposite party. He has not yet come to the court. I have filed the certified copy of the said order before the court below.
See,
Same
the
has not been
idea of
accepted.
issuing notice is it is a 138 case.
He's not
if
coming-
he come
he's not-
forward, then we can try to settle it.
He's not-
That was the idea.
He is not, in spite of received a note, but notice in admission matter written answered to open to with postal endorsement. In spite of issue of the notice, but he has not come to the court. Even if I have submitted the certified copy of the order before the court below, some have not received my order till today.
That's your problem. Then there is no question of settlement. I'm just giving you liberty, go and argue all these things. Right up. When counsel for the petitioner seeks to withdraw this petition to raise all these points, either the prevailing petition before the trial court, and trial court is expected to do well to see that the complaint case disposed of as early as possible.
One line, man. It is a fact that I have not paid money to the present petitioner.
Sir, what I told you understood.
Online, man.
These are the evidences which is
Obliged,
come on record.
Obliged, man.
It is only the trial court which can appreciate.
Obliged.
Some evidence has come in your favor doesn't mean that you will file a 482 say that quash it. That court will deal with it. You will be acquitted. I have expedited your time.
Take it, man. Only one line for observe. It is a fact that I have not paid money to the present petitioner.
since the certified copy.
If I will not write, that will evaporate.
ठीक है जगह.
That is there.
Oblige
Therefore,
जगह,
that is
ठीक है.
there.
That is only my case, my lord. Right.
If that evidence is there, that will
Yes.
remain there. Even if I write or I don't write. Don't, I have expedited it. I said that the trial court will do well to see that the trial is concluded as expeditiously as possible.
It is on certified copy, unless for which for one line.
Don't do that.
Okay. Oblige.
Next.
97.
May I please?
Yes.
The quashing of proceeding on the ground of my lord, the compromise, and on the last occasion, my friend was appeared for the appeal number 2 and filed an affidavit, my lords. And so far the petitioners are concerned, my lords, they have came today. But affidavit of the petitioner could not be prepared, my lord, because in the later stage they came, my lord.
Okay.
So I pray that, my lord, today I am preparing, my lord, all the affidavit of the petitioners, and let the matter may be listed next week any date, so that we.
Yes.
Huh?
Yes.
14.
98.
My lord.
99.
99.
But I am for the petitioner in item 99. Lord, the noting has come that the on delivered
99, I have instructions to appear for the opposite party number 2. I have not received the notice. Let a copy of the petition be submitted.
Don't go enter the period.
98 টা অর্জন করে
He's entering a period.
সেটা নেই 90 টা অর্জন করে গত থর অবজেকশন করছিল ইটস এ কেস অফ 302 and there number this
Yeah.
302 case trial state
93.
90
Nobody appears.
Mentioned.
Mentioned. It was mentioned, you should have opposed. কেউ পারেন না? Huh? No, no. They have obtained stay and this is keep it on 20th.
alert
It's not
my
302 case.
yes
You should have opposed when they mentioned.
ଆଜି ଯେତିକି list is 150 matters ଦେଖିବାକୁ
That's they are taking advantage of this.
ଆମେ ଦି ଜଣ 150 matters
Anyway, 20th rakho, huh?
my lord,
Otherwise, you will vacate the stay. He has taken many adjourned. Yes. Yes.
my learned friend has appeared now for OP number 2. I have a survey copy. Let it come after vacation, my lord.
Also entered appearance for opposing number 2, filed Bokatnama. And the copy of the petition is supplied to police party number 2.
That's not yet been supplied. He will supply.
I'll supply it. Notice was what?
Please the matter.
Alert entry matter to continue, my lord.
Entry mode to continue.
Obliged.
Item 100.
Obliged, my lord.
100.
May I please?
Yes, sir.
So, challenge the cognizance order, my lord. The grounds that the matter already amicably settled within the parties.
Where are they?
Well, I will take notice. Because, my lord, the marriage are already dissolved, so
This is a matrimonial.
matrimonial.
Issue notice to opposite party.
Within 3 or less. By
Hundred
Monday. By Monday.
May I please, your lordship? 138 matter, my lord. 143A petition was filed. 40 lakhs check. The learned magistrate says 45 lakhs. 45 lakhs.
143A.
143A. Only 41% of that amount.
Deposit.
My lord, I am for the respondent in this case.
Accused.
Yes, accused.
What is 1%?
My lord, I am explaining. First of all, I am entirely disputing the check and signature.
I am not on merit.
My lord, because the amount is so, my lord, the amount is so huge, and I am so poor person because I cannot give that. Even 20% is around coming out 9 lakh rupees. It is not possible on my part to pay. And actually, thing is that they are in a habit of doing this. My lord, kindly peruse the page number. Lord, I will file a detailed counter affidavit to this.
आप पैसा नहीं तो कुआड़ा नहीं दो.
My lord, ମୋ ପାଖରେ ପଇସା ନାହିଁ. My lord, ମୋ ମାଙ୍କ
ଆପଣ ଜିତି ଗଲେ ବି କିଛି
My
ମିଳିବ.
lord, he is a person not having a medical.
ହାତ ଟେକି ଦେଲେ
Conviction ହେଲା ପରେ ବି ସେ କହିବ ମୋ ପାଖରେ ପଇସା ନାହିଁ ତ ଦେଇଯିବି ଆଉ।
Milord, he is not a doctor. ମୁଁ ମାଙ୍କୁ ଦେଖେଇବାକୁ ଆସିଥିଲି. Thereafter I
କୁଆଡେ ଆମେ କଣ ଗଲେଣି?
I came to know he is not.
That your lordship will decide now. We will give evidence here.
No, no.
It's not the point.
Milord, see,
Point
what a
is,
misuse of the
1%
check.
is very, very less, you know.
Milord, I understand, Milord, but he has misused. That is why the London trial court in session they decided given a nominal amount. First reject ହେଇଥିଲା. Thereafter given a nominal amount on when they taken I will take a fresh averment to file a 143. First
You file response, we'll see.
Deeply obliged.
Your lordship, all these things do not bear in the order itself.
I know,
If your lordship will look at the order, there is no reasoning.
I'll set aside and send it back once.
Let him give your lordship, that matter will be over.
Let the trial commence within 2 months.
Can it be settled? Can
Milord, I am not that much capacity to pay. He is doing the
Capacity is something different. You are liable to pay.
Milord, I have
then
not,
you are liable
Milord,
to pay.
Milord, I have several documents. I can prove my case very well in the court below that he has misutilized my check. Most of the jhagda hala ପରେ check ଟା ଭୁଲି ପଳେଇଲି, he has posted that check.
Anyway, file declare.
How does he get over 143A?
Milord, 43A may be discretionary power.
But the court won't decide.
Not fixed 20%. It is any amount that the London trial court in session feel good and proper. Now in this trial court, considering the entire thing,
he could have completely waived. Instead of that,
once they have completely waived. Thereafter, the accused the petitioner came to this honorable court. Honorable court directed to file a fresh petition. After considering the fresh petition, again the same thing came to the surface before the honorable trial court.
let us see what are the material, whether his reasoning is written or not.
Yes.
No,
Your lordship,
no reason.
your lordship, there is no reason.
That's the problem.
We are confined with this
You
order.
have to justify that. You know,
Milord,
1% you have to justify.
I will justify, Milord. I may kindly direct it to file count.
Yes, yes. Yes, next.
Order but date, go to date, your lordship.
Date.
In June, your lordship's matters are going to.
No. June. Beginning.
After vacation.
Come on 19.
19 ମୋର ଶଳାରେ ବାହାଘର ଅଛି।
That I don't dispute, my lord.
I will
provide our rights.
After vacation ଆସୁ
After vacation का କଥା କହୁଛି।
ଏଇ ମାସ ନୁହଁ।
19 June।
19 ଜୁନ ଶଳାରେ ବାହାଘର ଅଛି, ତା ପର ୱିକ୍ ନେକ୍ସଟ ୱିକ୍ ଅଛି।
ତାପରେ କରିଦେବି। ତାର ଟାଇମ ନେଇଯିବୁ।
In the meantime, we could come up with the
out of court coaches.
Come with some suggestions, come with some extra.
And some sort of money, that's it. Let us be reasonable both sides.
My humble prayer, I am personal prayer, 19 ତାରିଖ ଦିନ ଶଳାରେ ବାହାଘର, 10 ତାରିଖ ଭାଣଜାର ବ୍ରତ।
ହେଲା ପରା ସାର୍ କହିଲେ 24 ତାରିଖ ପରେ ରହିବ।
ହଁ 24 ତାରିଖ ପରେ।
Yes.
I'm praying for an adjournment.
100 to adjourn.
Lordship, after vacating interim order is there.
Interim order to continue. Huh?
100 to delivery subject.
103. 103. Yes.
May I please, Lordship?
Yes.
Lordship, opinion 406 and 425 PC, the matter is amicably settled. I have filed the joint affidavit.
Where are they? Both are parties are. Parties are there.
Lordship, the bank draft of.
Receive, Mr. Maharaj.
Yes, sir. So Lordship, first see the cause list, my lord. Flag D.
103.
103. Flag C or flag D. Flag C रे 7 lakhs the गोटे DD अछि.
Yes. 7 lakhs and 1 lakh.
Yes, sir.
Yes.
Yes. Now, yes, look at president.
Yes. 420 only.
Lordship.
420-406.
Lordship. Yes, 14. Next to the charge sheet.
Yes.
Court already deposit करछंती flag C and D.
So original draft is
That will be
8 lakhs.
Yes, that will taken by the informant. Previous order you lost mechanism. Who direction did you deposit? You so much.
Wanted
They
to
so
know
much.
who is accused?
Accused.
He is complainant.
Yes, sir. I have started.
You've taken 15 lakh 30,000 rupees.
Bundu.
The allegation was for 15 lakh 30.
And you've taken and promised him to take him to Canada.
Yes, sir.
And now you are paying 8 lakh.
Yes, sir.
You are agreeing with
Initially-
that.
Sorry to interrupt.
Huh?
Initially, when I have been given the bail, I have deposited 3 lakhs. Now it is 8 lakhs. Only the transaction was for 11 lakhs 30,000.
You are agreeing to that?
Yes.
Yes.
No problem?
No.
Shall I quash it?
Yes.
Yes, sorry.
Do you have any reservation?
Sorry?
Do you have any problem?
No, I don't have.
No problem. Let the instance of opposite party number 2 sign FIR number 2 sign number 2
Thank you for the Thank you.
allegation is signed
Aadhaar card xerox kar rahi
allegation is FIR is that the
Upon division then
petitioner has promised the opposite party number 2 to take him to Canada and provide him job. And in that detail and taken 15 lakh 30,000. 15 lakh 30,000. However, subsequently the petitioner came to know that the promises are false promise and he has been keep. Now, therefore, the trial was back. And after investigation, charge sheet has been filed on 23/11/2021 for alleged from 420 and 406 IPC. Before the trial commenced, the parties have settled the dispute. The petitioner and opposite party are present in the court. They are being judgmental by the party. Affidavit you have filed?
Yes,
Give the affidavit. The petitioner joint affidavit.
That is on record.
Yes, joint affidavit.
Joint affidavit
Dated 17/4/2020. At the stage of bail, the petitioner has paid 3 lakh rupees to the opposite party number 2, and they have also and 8 lakh rupees. So he is paying 8 lakh rupees to the petitioner. Therefore, the opposite party number 2 for the petitioner is paying totally up to 11 lakh rupees. Settlement. In the affidavit, the petitioner says in the joint affidavit, the party drafted that in terms of settlement has enumerated in the affidavit. The contents of the same shall be treated as part of the Maharaja submits that the dispute is the interested party and the money the petitioner has already paid 11 lakh rupees to the opposite party in lieu of the settlement. In lieu of the settlement, so there is no legal impediment watching this back.
104.
সেটা নব ড্রাফট আউ চেকটা নব সেটা
Deposit here.
Yes, deposition.
Draft of 2 drafts.
No, one draft check.
One draft.
One check.
তাকে
Check টা ডিজাইন হয়ে যাবে
Draft of 7 lakhs and the check of rupees 1 lakh.
1 lakh
Which is deposit both. Handed over to the
petition opposite party number 2.
And the petitioner undertakes to report that the check of 1 lakh rupees which he has paid shall be honored on presentation.
Yes.
On presentation. Subject to the check is honored and
অরিজিনাল রেটে জেরক্স করে রাখি সে জেরক্স উপরে সাইন করবে ফাইল সাইন করবে
And deposit the check and inform this court that it is honored. Yes. Next.
104.
The marriage between petitioner and informant has been dissolved by decree of divorce on mutual consent. Notice has this honorable court issued notice. In spite of the notice, the informant wife did not appear before this honorable.
Service is complete. Complete.
Paisa nahi jayche, already tonka nahi. Annex.
Service. One more attempt you take.
Interim order.
Interim order will continue. Service the notice was issued to opposite party number 2. Despite service for opposite party number 2.
That date address such.
The letter counsel for the petitioner submits that he will make an attempt to serve the opposite party number 2 in the alternate address. In the alternate address by the
Address.
leave the matter on the interim order to continue. Yeah.
I would have said separate affidavit.
100?
Separate
105.
Date may fix it.
Date. You will get a date. Yes. 105.
In compliance of the order of the Honorable Court, the petitioner has been to the learned court below to surrender money for the but learned court below didn't comply of the order of the Honorable Court. Instead of he said that there is a typographical error and para 4 of this order dated 10/4/2024 and so.
Error taken
He is saying that instead of surrounding, that should be appearing before the learned court. That
surrounding the lekha is surrender.
No, surrender बदल
spelling mistake.
Surrender बदल रहे से क्वेश्चन appearing लिखे होते हैं.
I didn't understand.
हमको तो कॉपी दो बनिया में केम दिखो.
No, I have already saw the copy, my lord.
Where have we didn't?
Para 3, my lord. Para 3 on my petition.
सब ठीक अछि सेटा सब ठीक अछि सीट किए कोया को सरेंडरिंग लेखा हबो नि
Para 4
appearing लेखा
Para 4 of which order?
Para 4 of the order dated 10/4/2024. I have stated in my para 3, my lord.
Para 4.
High Court order.
What is this?
ठीक है कोया को सरेंडरिंग लेखा हबो
appearing he will decide.
आपण ताको रिजेक्ट करी कान दो
कौन तो रिजेक्ट करो
रिजेक्ट करू ना किछि मॉडिफिकेशन हो
what is wrong in it?
Appear or surrender or brought before. Three things is same before the magistrate.
Where have you said that magistrate is saying that? I'll call for a report.
Para 3 of my petition, my lord.
Let's see. It is this. Modification.
6/5/2024.
ଆପଣ ଦେଖନ୍ତୁ ତା ଭିତରେ କାଗଜ ଗୁଡାକ ଅଛି ତମେ ଦେଖନ୍ତୁ କେତେ କାଗଜ ଅଛି ଏତେ ଗୁଡା କାଗଜ ବାନ୍ଧୁଛନ୍ତି ତମେ ଜାଣିପାରୁନ.
Petitioner is staying in Jharkhand, my lord. She is a lady.
ମାନେ ଅତି this court directed the petitioner to this court by order dated 10/4/2024 directed the petitioner cancel the NBW issued against the petitioner and directed the petitioner to surrender to the jurisdiction of the court below and avail remedy as per provided under law. When the petitioner appeared before the court below, it appears the
6/5/24.
court below on 6/5/2024. It appears the magistrate refused to what have you said?
Execute the order.
Refused to take what have you written? Comply. He is not complying. Refused to comply the terms of the order dated terms of the order of this court dated 14/10/2004 on the ground that instead of appearing
Surrendering.
Petitioner is surrendering before this court instead of on the ground that
Instead of
there is a
appearing.
there is a typographical error.
Sir.
That instead of appearing, surrendering is found mentioned in para 3 of the order dated 10/4/2024. Therefore, the petitioner is seeking modification of the order in terms of the aforementioned terms of the aforementioned condition. I am surprised. If the contention is found to be true, it is very surprising that the magistrate is not complying the order of this court. To ascertain the fact, a report shall be called from which magistrate is that?
JMFC 3, my lord.
JMFC 3, Bhubaneswar. By next week, Monday.
Yes.
Monday. Call for a report.
Report us.
The registrar is directed to forthwith communicate this order to the magistrate.
Yes.
Yes. Next.
106.
ये कौन कहती है ये कौन लिखुଛନ୍ତି भगवान जाने
ଆସ ଗୋଟେ ରିପୋର୍ଟ ଆସୁ ସେ ମନା କରନ୍ତୁ ନା ସେଟା
magistrate might not have said that they might be interpreting something we don't know which magistrate will do this
ସେ ତ କହୁଛନ୍ତି ଗୋଟେ ପ୍ରାକ୍ଟିକାଲ ଯେତେବେଳେ ଡେଟ୍ ବି କହୁଛନ୍ତି
maybe some problem if there is some communication gap he might have said something and they might have understood something on that basis and moving application
ଆସ ରିପୋର୍ଟ ଆସିଲେ ଜାଣିବେ
yes
106.
Notice could not be issued due to non-filing of requisites.
Entry model to 9, the notice was issued to the opposite party number 2 by the order dated 22/4/2024. The requisites have not been filed by the petitioner, therefore notice is not issued. By way of last and final opportunity, 1 week time is granted to the petitioner to file the requisite. In the event the requisite is not filed within that time, the present matter shall be dismissed without further reference to the court. Yes.
107.
May I please, your lordship, my lord, modification for correction of error at para 5 of the order, my lord. Error of G.
Which order?
Para 5 of the order, my lord. 4/4/23 ଜାଗାରେ ହେଇଯାଇଛି 17/6/23. 4/4/23 is the date of NBW, my lord. ସେଠି
କଣ ଦେଖୁଥିବେ ସେଟା ତ ପ୍ରୋବ୍ଲେମ ନା
ନାଇଁ my lord, I have mentioned
ନାଇଁ ଫାଷ୍ଟ ପାରା 3 ରେ ଲେଖା ହେଇଛି ଠିକ କଥା
ଠିକ ଲେଖା ହେଇଛି
ପାରା 3 ରେ ଠିକ ଲେଖା ହେଇଛି 4/4/2023 କିନ୍ତୁ ପାରା
3 ନା
ନା ପାରା 5 ରେ ସେଟା ଭୁଲ ହେଇଯାଇଛି 17/6/23
4/4/23 ଜାଗାରେ 17/6 ହେଇଯାଇଛି
ପାରା 5 ରେ ନା
my lord
4/4/23 वाला 4/4/23 वाला था लिखा है 17/6/23 डेट को कौन करेक्ट करो ठीक
यस
देखिए कहबो ठीक है
सरेंडरिंग डेटा ठीक है तो
नहीं अपने आपण पूरा पुणी टाइम मागे सरेंडरिंग करने
एक्सटेंशन हो ना
my lord, time भी
कहबी ना
30th May
30 जून करो
ଅଛି
30 जून कर
30th May ଅଛି ହେଇଯିବ
କରିବେ ତ
ହଁ
ତ ବଢିଆ କଥା
ଆଜି କେତେ ତାରିଖ
ଠିକ ଅଛି
वेरी गुड
ये बहुत ही ठीक है
30 ତାରିଖ ଅଛି
हां ठीक है
oblige me
don't ask for further time okay
no my lord
yes 15 June for me again the last time 15 June करती on or before 15 June so that if you want to do it
oblige highly oblige
otherwise again you move application
highly oblige my
15 June on or before
Council waiting 1%.
30 degrees how many matters are there
108 টা উইথড্র হয়ে গেছে
Sorry, withdraw.
then
109.
these are the appeals
109 this is appeal your lordship had directed
this appeal is problem is Mr. Das mother is expired so he has requested
10th day
it's better that we shouldn't take up.
but
No, it will remain in the list.
remain in the list
Let it be there.
the
paper book ta prepare କରିବା ପାଇଁ କହି ଦେଇଥିଲେ ମୁଁ I am ready and willing to
Which one?
deposit the cost
Which
paper
one?
book
Which
cost.
one?
ଏଇ 100 ନରେ
So no paper book.
paper book ଟା prepare କରିଦେଲେ ମୁଁ I will pay the cost.
Prepare
They let the office
Receive directed to prepare the paper book.
ନାଇଁ ନାଇଁ 109 ଟା ମିଳିବ 109 ରେ ତମର କୋଡେ
Paper book ठीक है.
paper book ଟା ମୁଁ I will deposit the cost. Your lordship may directly register to
Deposit the cost of preparation.
109
I have the similar prayer in item number 112 and 113.
এই 109 ରେ last ମଝି କେସଟାରେ ମୁଁ ଅଛି I may be also given a paper book.
Copy office will supply, my lord. I will deposit the cost, my lord. Because here the difficulty is, my lord.
Why can't you think that why should you prepare paper book and all? It take in pen drive and all evidence is there to decide it.
बिना paper book रे भी
Effective way of doing it.
नहीं last date रे
I am making that order.
Yes, yes.
Paper book.
No, the paper book is concerned, it is required. Because pen drive रे हम सब जगह में नहीं परिबुनु.
काहे नहीं परिबुनु? Pen drive ने laptop रे करियो. Paperless code.
Paperless code.
No. See, no.
we have
ଆପଣ ଗୋଟେ କାମ କରନ୍ତୁ, try କରନ୍ତୁ, ନହଲା କରିବ.
ନା ମୋର ଟେକ୍ନୋଲୋଜିକାଲି ଆଇ ଏମ୍ ସାଉଣ୍ଡ ମୁଁ ସେଥିରେ ପ୍ରୋବ୍ଲେମ ନାହିଁ କିନ୍ତୁ କଥା ହଉଛି ଯେ ସେଟା ଟିକେ ପ୍ରୋବ୍ଲେମ ହବ ଲେଟ୍ ଦେମ୍
କିଛି ପ୍ରୋବ୍ଲେମ କିଛି ହବାର ନାହିଁ nowadays modern cases are also
pen drive ସବୁରେ pen drive କର we'll see if any some difficulty comes then we'll see
ନା ତାହେଲେ ଏଟା ଆସୁ ଆଫ୍ଟର ଭେକେସନ ଆସୁ ଏଟା
after vacation ହବ
you I want to make you sound
also trying to be sound. And I see in
they see we are following paperless codes and we have to start doing if there is some difficulty
more problem
list in the list
after vacation
bring the pen drive
yes
ask our court staff they'll give you the entire trial court record then we'll see how we will proceed let us see
that will be
matter korea jodi problem achi then we'll see
after it can be decided my lord because he was insisting that
ସବୁଆଡେ କରୁଛନ୍ତି
after
your lordship must have done it also there.
Lordship, the next item 110 another
after vacation
same sir ଆପଣ pen drive नहीं जानतु
ना ना से paper book ଦେଇଛନ୍ତି
paper book ତ ଅଛି ଆପଣ ready
let it come after vacation
moon sir paper book is ready in your
yes I have received
it can be heard let it be there in the board itself
lordship
regarding lordship 112 and 13 I may permitted to take the
standing order
lordship
you can any day you can come and take
oblige
सब board रे रहइबो sir yes call 100 15 14 so हो गया all criminal appeals are all criminal appeals remain
111 melody is different thing. That interim order is there till because they have filed an application for vacation of stay.
But Mr. Das is appearing in
interim order to continue up to interim order continue
next week as कारण सेतरे stay vacation
not possible नांदी सेदी में एडजस्ट कर दो why
the last में record that
his mother is expert to let it come yes
next your lordship pardon to mention item number 123 and 124 in those matter I filed a vacation of stay so the matter may kindly be taken up expeditiously on any other
it will remain in the board don't worry next 115
may I please lordship my lord your lordship
and he has mentioned 120 you mentioned
123 and 124 your lord
125 is mentioned in the morning
yes
let us take 125 let us see who is there
then let pardon to make a mention 117 there is an interim order
continue,
to continue and 120 it may be adjourned after vacation
my lord 117 is my matter my learned senior just mentioned I'm for the
all the Ms. Naidu, all the matter will remain in the board unless it is adjourned.
No, so that is not. My learned senior mentioned my matter instead of his. That is what I was mentioning.
Okay,
his
he's asking for us.
160.
my lord choice টা
My lord, 116টা Mr. Singh, Mr. Moon was asking for time. That is 116, 117. 116.
Again. 117টা more. That is what he mentioned the wrong.
And 119 সেটা মধ্যে আছে।
My lord, 119,
Yes, 125.
119, both are here.
One.
I am given to understand that similar matters are coming on 26th June.
No, 26th, no, 28th.
28th June.
Urgent 20.
On that date, your lordship can take it up.
No,
Yes, 125. 1 minute,
May I
125.
please your lordship?
Who is appearing for petition?
My lord, ଆଉ ଦିଟା ଅଛି ଟେ ଖାଲି ଆର୍ଜନ କରିଦେଲେ ଯିବ 120 122 and 129 120 122 129
122. 122.
So, Madam, mentioning is not going on. Matters are going on. Wait. When I'll rise, I'll call you. Don't worry. Don't worry. 125 is called. Let us see the 120.
In 122, my lord is mentioning, my lord, that I may file an application before the trial court so that the matter will be adjourned.
No, it's a matter.
I make an application.
Sir, it will remain in the board. When it will be taken up tomorrow, you tell me.
My lord, so far tomorrow is concerned, I have some difficulty. In this case, I have filed the counter and
It's for final disposal.
it's for final disposal. Let it come any other date next week. It can be, I have already submitted my
It
notice.
will remain in the board. If not tomorrow, Monday. Let it remain. Yes, 25.
Item 125 are two matters stand.
Yes.
One is, my lord, criminal MC 2909. That, my lord, is the lead matter. By this petition, my lord, the Central Bureau of Investigation seeks to, my lord, challenge two orders to the
It is our
same
petition.
effect.
Your lordship, it is our petition. We are supposed to start.
Yes, Mr. Naik.
Petition has been filed by CBI, your lordship, not by the opposite side. So I am supposed
yes.
to. Yes. Now, your lordship, may kindly, there are two connected matters. One is CRLMC number 896 of 2023. I would like to start with that because your lordships had already heard it in part.
890?
896 of 2023.
Yes, yes.
Where your lordships may kindly come to page 82, where the cognizance has been taken by the London magistrate.
82?
Yes, page 82 of my petition, your lordships.
The second petition 82?
Second petition, page 82, your lordships. Peruse the charge sheet along with the connected documents, papers filed by the IO, CBI. A perusal of the records prima facie show commission of offence punishable under section 7, 8, 9, 10, 12 of the PC Act, as well as made out for the involvement of such and such persons. Now, your lordship, this Sarosh Das, he is a public servant. He is the mechanical engineer of Paradip Port, your lordships. Now, lordships had read section 19 of that. The previous sanction is necessary for prosecution, and the language is that no court shall take cognizance of an offence punishable under section 7, 11, 13, and 14 alleged to have been committed by a public servant, except with the previous sanction. Now, lordship, the language is shall. The statute prescribes a thing to be done in a particular manner, your lordships. It has to be done in that manner. Lordship, may kindly come to the charge sheet for a moment. Para 16.41, page 47 is the charge sheet.
Page 47 of which case? First case, second case?
896, your lordship, 2023.
Yes. 47.
Page 40, para 16.41. That sanction for prosecution against the accused public servant Saroj Kumar such and such have been sought from the competent authority, which is awaited. Now, lordships, when the statute is clear that cognizance cannot be taken for an offence punishable under the PC Act without a clear sanction, and in the charge sheet it is written that sanction is awaited, your lordships. So there was no extraordinary hurry to take cognizance of the matter. And your lordship, when the accused may take in future also, he may be discharged or he may be acquitted due to this invalid sanction, your lordships, or improper sanction. Now, sanction we have already obtained.
Now, what is the stage now?
Now, lordships, he has taken cognizance. Trial has not started. The stage is that, your lordships, investigation is pending because we have to take.
207 as 207.
No. Have you got the sanction now?
Yes.
We have filed it. Let the matter be remanded back and he will look into the sanction and pass a fresh cognizance, your lordships. What is the problem? He will not be prejudiced also.
My lord, may I
See, the
only
sanction was awaited.
correct, my lord.
And what was the hurry to frame the charge, take cognizance and proceed with the matter? Now,
Yes.
since now they have got the what do you call the sanction?
Correct, my lord.
then ideally it should be set aside and remanded back, whatever.
May I, Milords, with your Lordship's permission, just Milords assist as an officer of this honorable court. Would your Lordships kindly have a look at Milords chapter 35, section 460 of CRPC for a minute?
Yes.
Now, my lord, section 460 says irregularities which do not vitiate the proceeding. And my lord, subclause E thereof says that to take cognizance of an offence under clause A or clause B of section 1 of section 190. Now, if your lordships have a look at section 190, the clause B of subsection 1 is based on a police charge sheet.
Yes.
So, my lord, now please have a look, my lords, now at section 461.
Yes.
Then, my lords, may see subclause of, my lord, subclause L is tries an offender. So, insofar as, my lord, the procedure under CRPC is taken into consideration, though this is a challenge of CBI to its own case, but I am, my lords, only to assist as an officer of this honorable court. Even if the learned special judge takes cognizance of the offence without a sanction being there on record, it is merely an irregularity which doesn't vitiate the proceeding. However, if the learned sessions judge, my lords, or the special judge tries the offender, only then the trial is vitiated.
Right.
So if he wants, my lord, that his own matter be remanded back for fresh cognizance, I do not have a problem. But insofar as now when the sanction is placed on record, my lords, the order, my lords, does not now suffer from any kind of vitiation which will knock out the entire case,
right?
Because the provision of 460 will come into play. No prejudice will be now caused to the CBI. Actually,
Shall I record your statement and dispose it?
my lords, as far as I am concerned, 7 is a different my lords counsel who is directly appearing for the public servant.
Mr. Naik,
But my lords, it affects
Mr. Naik,
equally.
the apprehension which you have, that tomorrow they may take a stand that the entire prosecution is vitiated.
No, that we will not take.
So they are making a statement.
That
What
we
is
will
the
not
problem?
take.
Your lordship, how is prejudiced and why, if nothing will happen, why is arguing your lordships? Lordship may remand back the matter to the lower court. In the light of the fresh sanction issued, he may take cognizance as per the procedure which is available under section 19.
So I think both of you are in the same page. He wants to follow some procedure, you want to follow some procedure. It's all right now.
Milords,
Any
the sanction is already.
That's right. There is no dispute to that.
How is prejudiced if the matter is remanded back, your lordships? What should be my
Prayer is confined for quashing, and right now he's preparing for remand.
No, that is all right. Milords, insofar as we leave it entirely, Milords, to lordship's discretion. Though, Milords, cognizance of the offence is taken only once. However, if that cognizance is set aside, then, Milords, it is a matter of fresh cognizance under 190 and, Milords, a fresh summons under 204, which then leads to a fresh procedure under 207.
No problem.
And subsequent death.
You get a fresh opportunity to challenge us.
Milords, we would not benefit from this kind of an exercise. Actually, Milords, I would like to, Milords, argue the other case. If he wants a remand, Milords, it's good. If he wants a remand, Milords, it's all right. Otherwise, as an officer of this honorable court, I would say it's merely an irregularity which doesn't knock out your case. It doesn't, Milords, knock out the case. It only, Milords, enhances the time that the court will now take for a 190, 204, 207.
That tenure to your benefit.
Your
Milords, it doesn't matter.
Your lordship,
it really doesn't matter.
There is a legal impediment, my lord. If the order is quashed, the second cognizance is barred by law.
Then that opportunity you have to argue. He is bargaining that risk.
Second
He is
cognition.
bargaining that risk.
No, I am
No,
not
he will take a plea that this since the
I
High
will
Court.
see, it is remanded, it has
No,
to-
your
has to
lordship may
satisfy.
see the prayer.
And the court will take its own course.
Your lordship may see the
No.
prayer.
Your
Lordship may
lordship,
see the prayer.
Forget, on his request, I am getting
no.
it back and remanding it back. Whatever the consequence, he has to face it.
Yes, my lord,
Why do you-
it is at the option of the prosecuting agency.
Prosecuting agency says that you quash my cognizance order.
Yes, my lord.
This is the beauty of this case.
Be quashed, my lord.
And whatever the consequence, is the benefit inured to you and take it.
Very well, my lord. Very well.
I'll set aside and remand it. Set aside and remand.
Yes, my lord.
Yes.
But it in the light that phrase sanction should be taken into consideration, Your Lordship.
No suffix prefix. Simply set aside, remanded back on the light of the fact that fresh sanction you have obtained and place it on record.
Yes.
And the court will take its own course.
Yes.
And whatever benefit.
The consequences are as they are, my lord.
Legal consequences.
Legal consequences are as they are.
I will not record your statement also.
No, my lords, I didn't even want to. I was just, my lords, assisting on the procedure as covenanted. Because, my lords, once we are here, then we are bound to assist fairly.
Yes.
Okay, I'm setting aside and remanding it back to the court below.
Yes. Now, my lords,
deal with the matter in accordance with the law.
Correct.
Yes.
May have
I will not even say that take fresh cognizance, whatever.
Oblige, most oblige.
I'll simply say deal the matter in accordance with the law.
Yes. And, my lords, upon their request.
Obviously.
Well, obviously.
I'm dealing with I believe.
I have not requested. Your Lordship,
Second matter.
896 of 2023.
Your Lordship, I have not requested anything. My limited submission is that, Your Lordships, without a valid sanction, cognizance cannot be taken. This is illegal. Sanction it has been filed, and Your Lordship may decide what to do.
Yes.
As per law, not my request.
That's okay.
Your Lordship, I come to CRMC for 2909 of 2022.
Now
I'll record your submission, then whatever I was supposed to do, I'll do. Okay.
My submission, Your Lordship, is that.
But I will dispose of the matter on the strength of your submission.
Yes.
Okay.
Now, Your Lordship, may kindly come to CRLMC 2909 of 2022.
That's the second case, my lord.
Second matter.
2909
is the second petition which is tagged.
Yes. What is this?
Lords, let my learned friend start, my lord. It is his case.
The first item, the first item, first item 896.
I don't know, Your Lordships, if Your Lordships knows Mr. Tanveer Ahmed Mir, he marathon 3 months, he argued for that Arushi Talwar's matter, Your Lordships.
I know.
Lord, Mr. Naik, my lords, like a younger brother, my lords, we've worked on many an assignment together, my lords. I'm an absolutely brilliant lawyer.
Yes.
Your Lordship, may kindly come to Annexure 5.
5.
Page 58 to 67, which we are challenging, Your Lordships.
Yeah. Is there any urgency today? See, at this time, the other lawyers are waiting. It can be heard little later.
Your Lordships.
It can be heard little later.
Yes,
this matter you urgent. This matter you urgent.
Yes. May I, my lords, only request if it can be, my lords, part heard, then we can, since one matter is.
Or Your Lordship will fix a date so that.
Our, my lords.
We are fixing a date.
Yes.
Yeah,
Tanveer, part heard doesn't make any difference.
Well, doesn't matter, my lord. This was, my lords, more an interesting matter to argue.
Yes. Let it be immediately
reopening.
Opening in the sense 19, 20, 20th. Okay, 20th June.
Sure, 20th June.
20th June?
Yes.
20th June?
20th June? It's all right.
20th June.
Thursday.
Yes, my lord. 20th June.
Yes. Yes.
In seat 96, my lord, I am appearing for Saroj Kumar.
I don't think this, no? When you are appearing.
I am appearing for Saroj Kumar.
Mr. Tanveer Ahmed is appearing for opposite party number 5.
Item 36.
ये देखिए फिर कुछ लिख दूँ ये कहाँ पे appeal
Item 36.
हाईवे पे opposite party number 5
Only 26. 36. Only 36.
Your lordships are directed to take this matter at the end of the board. But my lords, my senior Mr. Kanungo is yet in another court. So
What time?
my lords,
9 o'clock in the night.
my lords, it's still before.
We have adjourned the matter. You came interjected. You said that it should be taken.
No, my lords, at the call I was here.
Adjourn it.
Another matter.
At the request.
My
Another
lords.
matter will also 56 item. 56 item will also directed to be listed tomorrow. But till date, but I am here before the also I have not able to.
That is contact
the SP.
My lords, item 36, my lords.
Oh, that girl. Child.
Monday को रखा तो सब instruction नहीं है.
Monday को भी.
My lords, item 36. Item 36, may I pray it come up on Monday, my lords. So my difficulty, my lords, is that the trial course.
You are concerned about your difficulty only. You are not concerned about the
No, no.
difficulty of the court, not difficulty of other lawyers.
I understand, my lords. My lords,
What is the time now? We are accommodated in the morning
My lord.
now, and you want further accommodation.
My lords.
Leave it to us. We'll see how can we. Yes.
The discharge petition has been
Maybe
rejected,
whatever.
my lords.
Matter is listed, you are wasting time. The other people are waiting to hear.
I
argue
understand.
that.
I apologize.
Yes.
Item 115.
Item 126, the next item, your lordship. A matrimonial proceeding out of which this present case arises. I am seeking quashing of the FIR filed under section.
What do you want now?
My lords, on the other day, your lordship was pleased to direct that the petitioners and the opposite party to be present on the.
Are they?
The petitioners are present.
Opposite party also. In the VC. In the VC.
My lords, if my lords.
126.
126.
My lords.
1 minute.
Parties are present.
Yes. She is. Priyalata Patra, kindly.
Yes,
kindly
present,
come on,
sir.
VC. Yes.
Good afternoon. Yes.
Poor person, we cannot.
If there is a judgment, if you are agreed by a judgment, then appeal lies. No modification. If it is not a proceeding, I pass a judgment, wrong, right, whatever. If you are agreed, then you have to go to appeal.
Challenge the order.
All order का नहीं दोस्त
judgment trigger करो सर क्या चला
नहीं आपण नहीं नॉर्मली इट इज 5000 1000 टाइप रो फाइन है और 25000 बोली कि हम
want to go to jail but even if you don't pay who bothers land revenue recovery करिवे land revenue तिले करो
ऑलमोस्ट ऑल रिवीजन 500 टका 1000 टका ई टाइप रो फाइन है
problem is this is a judgment I can't correct it.
That side, while setting side the sentence.
Modify the judgment.
What's this? What's it?
Already disposed of and passed.
Yes.
25 days. Kitne jail hai?
So all right, who bothers?
So lordship one item number 134.
I may be pardoned, my lord. Item 129. On the last occasion, my learned brother had taken time to file counter. But till that, they haven't filed any counter, madam. And my trial court date is on 13th of May, this Monday. So I pray for continued.
What is that case?
This is the
29, huh?
129. And my interim order to be continued, madam.
Interim order continue. Interim order is there. Continue. What is the problem?
118.
Pardon to mention one.
118, madam.
First
hour, madam, I have.
Which one?
118. I have missed the list, madam. That portion I have missed the. That matter will be taken up fast.
First item.
Yes, that was.
Is not present.
I am appearing today, madam. So your lordship fix it any day after vacation, any day.
What was the matter? Why it is first item? There must be something.
Mention it. Mo pago agar
1,
transfer
2, 3, 4, 5, 6, 7, 8, 9, 10, 11 dates you have.
ମୋ ପାଖକୁ ଟ୍ରାନ୍ସଫର ହେଇକି ଆସିଛି ମ୍ୟାଡାମ କେବଳ ମୁଁ ଆଉ ଗୋଟେ ଆପଣ ଯଦି ନେକ୍ସଟ ୱିକ୍ ମଧ୍ୟ ରଖିବେ ମୁଁ ରାଜି ଅଛି ଖାଲି ମତେ ଟିକେ ବ୍ରିଫ ଯିବା କାରଣ ଏଟା ଟିକେ ଗୋଳମାଳିଆ ବ୍ରିଫ
118 I am for the
ଗୋଳମାଳିଆ
opposite party.
ଆଜ୍ଞା
But he is appealing for the appeal party.
And the stay order is continuing. A DB proceeding is
No.
stayed.
not in the 8000 I am paying madam
20 दिन रखे होगे 20th तक
yes
Pardon to mention, my lord.
My lord,
Interest
132.
continue.
Item number 132, my lord. Last occasion, opposite party seeks time to file the counter. But till yet, they have not filed the counter. We have also not received yet.
All these matters which are I am not taking up today, that will remain in the list.
Remain in the list, yes.
Lordship,
Lordship,
one-
141, may I be pardoned to mention, my lord?
Next week, no.
Lordship, I pray,
All these matters will.
Pardon to mention.
I pray
item
that kindly be
128.
taken up after vacation, your lordship.
Which one?
132.
132 after.
Interim order to be
141,
continued, your
my
lordship.
kindly
item
be
number
taken up after
122, my lord.
vacation.
Obliged.
141, my lord, 141.
Sir, all the matters will remain in the court.
I know 128, my lord, can
Maybe
be taken
adjourn.
after vacation, my lord.
Who
120,
wants an adjournment
my lord.
after vacation, tell him he will adjourn.
My lord.
Grateful, my lord.
280.